All right, we'll do a quick restart. I think people who are dialed in can hear now. I didn't realize that the court mic was not pushing out into Zoom land. To briefly recap, this is the call of a one-week trial calendar that starts on Monday, as in a few days from now at 9 a.m. And we'll be working through the few remaining cases on this calendar. Most have resolved. To see what we will try and what jury will select on Monday morning. And I had gotten to Mr. Gentle. He is not in court, which is concerning to me, but at least two of his lawyers are on the call. So maybe they can explain to me where Mr. Gentle is.
He's present with me, Judge.
Ah, okay. And you guys are not in court because who said that was a good plan?
We got notice via email that this calendar was moved from 9 a.m. and there was a Zoom attached. So we are appearing via Zoom.
Huh. Okay. State ready on Gentle.
Your Honor, the state has an offer that it needs to convey that I have been instructed by my supervisor to provide to opposing counsel. Okay,
another reason to have lawyers in court instead of Zoom for trial calendar calls. What's the best way for Ms. Williams to reach a lawyer for Mr. Gentle to talk about this new offer that a supervisor has instructed the lawyer to offer to Mr. Gentle?
Provide her my office phone number, Judge.
All right. Ms. Williams, are you on the Zoom?
I'm actually not on Zoom, Your Honor.
And you don't need to be because you're right here in court. I just was wondering if he, is that something you don't mind saying out here in public, Mr. Denslow, or?
Not at all, Judge.
Here it comes. You ready to write down the number? Lay it on us.
770-919-9525.
All right. We will pause consideration of Mr. Gentle's case, if you don't mind going into the jury room and reaching out to Mr. Denslow. But my question was, is the state ready, and not do you have an offer? If this offer isn't something that intrigues the defense, is the state ready?
Yes.
Okay. Mr. Denslow, I see that there was a motion to continue filed. I haven't been able to read it yet because I was doing other things this morning. We will address that after you and Mr. Gentle have a chance to ponder whatever it is Ms. Williams is going to share. I don't know that you two have met. Ms. Clark has historically worked on this case. Ms. Clark has been transferred to another courtroom for these type of cases, and Ms. Williams is taking over. I believe if it's trial, it will be a Clark Williams production on the state side, but at a minimum, it'll be Ms. Williams.
Yes, Your Honor.
Okay, so I don't want you to be surprised that, well, who's this other lawyer? It is a very able and capable replacement to Ms. Clark. Ms. Clark has just, like I said, been reassigned to a couple different courtrooms. So it'll be Ms. Williams who gives you a call.
Thank you, Judge.
All right. Julian Terry. Hello, Mr. Terry. Oh, this is the case. This is Mr. Tevis's case as well. Is Mr. Adams here?
He's on Zoom as well, Judge. Same thing. We got a Zoom link and a move to 1 o'clock, so I thought we were on Zoom, but he's here.
Okay, I see him. All right. I owe you, Mr. Tevis and Mr. Adams, some rulings, and I think Ms. Davis owes both Ms. Wood and Mr. Tevis some discovery. So this is not one that'll be going to trial on Monday, but we do need to get an update from the state because it's been like pulling teeth, not from the DA, but from whether it's the locals or the feds, getting this stuff that seems pretty discoverable.
Correct. We did have officers go down to South Fulton yesterday and supervisors reach out. They have been able to obtain search warrants, photos. They indicated the DVR that Mr. Tevis was looking for they said was not able to be dumped. So I guess they didn't retrieve anything from the DVR. Tomorrow is my understanding they're supposed to receive the cell phone extract.
Meaning South Fulton will receive it from someone, or your investigator will receive it from South Fulton?
Our investigator will receive it from South Fulton.
And that is the cell phone extraction of whose phone do you think it
I
is?
believe it's Mr. Adams' cell phone. I'm not sure if Mr. Terry had a cell phone. It might have been two cell phones though.
Okay. Mr. Tevis, was it your understanding that there have been an extraction of your client's phone, or at least an attempted?
I didn't know, but I think that the officer in our motion to suppress hearing had indicated they took phones, so
Okay.
I don't know.
Got it. All right. Well, it sounds like the state is wrapping its arms around more of this information. Ms. Wood, anything you want to share? Mr. Terry's here. He's usually here when he needs to be. So I'm not particularly concerned about the bond situation. Anything more from the defense?
We're going to continue speaking with whoever places the state.
Ms. Smith?
That's right.
Is Ms. Smith here? No? Okay. Can't wait to meet her. All right. Mr. Tevis, anything on behalf of Mr. Adams?
There was also some mention at the hearing. Remember, the officer said that FBI was involved, so they weren't sure they could get all that information, but that there was at least some kind of report on the activity. Remember, our case started, they talked about an event and some buys that were made earlier in August at an unknown date. He would give the information, but said that there was a report about it. So we were interested in having the information where they say there was an alleged buy or something involving Mr. Adams earlier in the month.
Okay.
That was the officer's testimony. I don't know if the state has been able to obtain that, but he said that even though he didn't know who the informant was or couldn't give that information, that there was a report about what they did that day.
Not exactly familiar with that information. However, it's my understanding that one of our investigators is going to be connecting with FBI agent Askew regarding the CI and basically the whole thing.
Okay.
They can provide.
Well, make sure your investigator does inquire about, are there any 302s, I think they call them, that might relate to their investigation. All right. Anything else, Mr. Tevis?
Nothing further, Your Honor. Thank you.
All right, you and your client are excused, and Mr. Terry, you're excused unless Ms. Wood needs to talk to you more, okay? Azelle Martin. Hello, Ms. Kurt. I am okay. Mr. Martin has 3 cases. They were on a final plea calendar a while ago. You had a conflict, so I preserved Mr. Martin's final plea rights and moved them to today with an eye towards resolution, and if not,
I think
we got Monday.
There was there's some discrepancies on his history, or maybe there's not, I don't know, we're trying to sort it so we can nail it down. I think we're real close.
So a couple things. One,
And I'm clear the rest of the afternoon if that's what you want.
good, I do, because close means we resolve it today or we gather on Monday. We don't have pretrial services on the call. They're often helpful at clearing up questions about criminal history.
And that's what we were waiting for, because based on my history, there may be something on there. I
Okay.
have it in my notes. I
Yep.
don't see it in the GCIC, and I said, well, let's wait to pretrial services to check.
Sure, well, we'll do some outreach there. If it's a Georgia felony case, Ms. Simpson might have some visibility into it. Not in your system at all? Okay, well, that's a data point also. I will ask Ms. Nelson to reach out to pretrial to see if we could get someone on. We need it anyway if we're resolving the cases today. So we'll see if we can, probably the switcheroo from 9 threw some people off. But Ms. Kurt, you think close means assuming the answer is going to be whatever it is the criminal history. And then Mr. Martin is prepared to resolve all 3 cases?
Well, I gotta talk to him, but I think so. I think we're there. This could happen today.
Okay, great. Keep talking. How about Kevin Bonilla Garcia?
Good afternoon, Judge. Good to see you.
Hello, Mr. Wallace.
There's no statement, General, right? Can you be there in person, never call? So we're here. Judge, we made an announcement last calendar that the state and I were in discussions, can you believe that those discussions they had? To make it a resolution date, is that, can you give us a little bit more time?
Well, today's the time. Ms. Williams, your case. And have you had an opportunity to familiarize yourself with the case?
Yes, Judge, and what we have done is to we have heard the case diversion.
And we are trying to get an answer back
Okay.
from,
This would be your office's diversion.
yes.
Okay. All right. And you made the referral or a colleague made the referral when?
I thought the referral had been made earlier, but my understanding is that it was made today when I made the inquiry.
Oh, okay. They usually don't turn it around same day.
They don't. They are very efficient though, but probably not same day, but we are hoping, we have some, I've got some very wonderful colleagues trying to make that happen.
Okay. Mr. Wallace, we're gonna all stay here for a little while and see what we can learn. Does Mr. Bonilla Garcia require an interpreter, or the young lady in yellow is taking care of that?
I am interpreter here. Nice to meet you. I'm one of the in-house interpreters now here in Fulton.
Oh, fantastic.
Yes.
Well,
nice to
welcome.
meet you.
Nice to meet you. Okay, good,
What I meant was, it was time, I meant to time today.
good. You have time today. Excellent. Thank you. I will check back in soon.
Ron Bass about to make that call?
Yes.
Thank you.
Yep, I bet Mr. Denslow is waiting on pins and needles. Rontez Way.
Good afternoon, Judge. That's gonna be a pleasure.
All right. There was a moment in time when I was in the car with Judge McAfee and you were going through the crosswalk, and it's like, ooh, what do we do here? Do we stop or not stop? And I voted to stop.
As long as y'all had insurance, you go, baby.
Yep.
Anyway, I could have found a lawyer.
Yep.
So I can't remember, do y'all do paperwork in here?
Not for this case.
Yeah.
There are some cases where we might, but not this one. So, we will be able to take that plea momentarily because I don't think I have any other cases left on the calendar. Ms. Cabrera, I see you on the call. Tell me why I'm always happy to see you. Tell me what's going on.
I think I had the last position on the calendar, Mr. Greer.
You did, and Ms. Nelson shared with me that you were going to be preparing some paperwork for me.
Yes. She's gonna walk me through the process. I know it's changed a little bit. We had the hearing for him the last time he was in court. And she shared there was some other different things that I may need to do in order for his evaluation to be done. So she's gonna-
Was he in court? Did we all talk about it together?
We did. He came, he
Okay.
sat at the table. You let us know we had to have that special hearing.
Yep. So all I need is if you could shoot an email to me and Ms. Nelson highlighting what your concerns were based on your interactions and what we learned at the hearing.
Okay.
Then I will be able to do the order. And I have a sealing order as well. But I don't even know that it needs to be under seal. Was the hearing with the prosecutor present?
Yes.
Okay, then if you can just send that email that highlights your concerns, I think we can take it from there, and then it will be Mr. Greer's in custody. So is he in custody?
No, he's out. He's on bond.
Okay, then it will be the situation where I will connect you. Once my order has been e-filed, I'll get a file stamp copy of it, and I will forward it to Ms. Green, Zarina Green, and you will be copied on that, and you and she will do the coordination about where Mr. Greer needs to be and when, probably one of my jury rooms, for the work that needs to be done.
Okay, sounds good. I can do that now, as a matter of fact. I'll do that now.
Great. All right, thank you so much.
Thank you.
All right, anyone here who didn't hear their case called? Ms. Willingham.
We have a add-on,
Oh.
Mr. Afternoon, we have Darius Heard for a plea.
Okay. Good afternoon. I did see you in here. I'm like, but I don't see an app case on here. Darius Hurd, can I have that case number, please?
Yes, it's 25 SC 003287.
All right. And would you say that's more ready for a plea than Ms. Davis's case?
It's completely ready.
Okay. So why don't where is Mr. Hurd?
He's right here.
Okay, why don't we do that, and then we'll do Mr. Way, and in the meantime, the lawyer, because that way Ms. Davis and Ms. Kurt can keep talking about the three cases that Mr. Martin has.
You want us at the podium or the table, Your Honor?
Here, podium, please.
Judge Mayor?
Yes, ma'am. Short and sweet.
Yes.
Have a great weekend.
You too.
Your Honor, can we step outside while we bring the answer?
Okay.
Yes.
Yes, please.
Yes.
Yes, and I don't see that, I thought it was like a show on, I can kind of stay. Yeah, I guess.
Oh, yeah, that is one that's in a evaluative timeout.
Thank you.
You bet. And Ms. Kurt, as soon as I see someone from pretrial on, what's the question I should ask? Just what's the criminal history? Is there a felony conviction?
Yeah, they're not, that's the one.
Basically, are you first offender? Well, these are 3 cases, but is there a prior?
I think that's my goal is to make it,
Consolidate for purposes of sentencing into one, and it would be first offender, assuming he's eligible for that.
which I believe he is, but
Okay,
obviously that could be contradicted, but I've not seen anything yet, he doesn't recall anything yet, so.
okay. All right, well, we'll try to get a definitive answer. All right, let me pull up. That's gonna come off tomorrow, but I'll address it. All right, Ms. Rivers, are you ready?
Yes.
Okay, let me do one more thing.
Yeah, I don't like the same thing, these are arresting, this is one day. Just check everything. What goes on? What goes on at the station, you gotta want the police report. You might say it was one thing.
All right, Ms. Rivers, you ready? You were ready before. This is 25 SC 003-287, State versus Darius Hurd. Mr. Hurd is at the podium here in court with his lawyer, Mr. App, and we have Ms. Willingham here in court for the state. Mr. Hurd, it's my understanding that you are prepared to enter a plea. Is that correct?
Yes, sir.
Okay. Ms. Willingham is going to put you under oath in just a moment and ask you a bunch of questions, hopefully all things you and Mr. App have talked about before. You need to answer those questions truthfully and completely. If at any point we get into an area that confuses you or you're wondering why are we talking about this and you want to talk with Mr. App, let me know. We'll pause. You guys can have a private conversation, okay?
Yes, sir.
All right. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Darius Alexander Hurd.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
I'm 32 and I have some college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need any more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I do.
Have you reviewed the indictment in this case?
Yes, ma'am.
Do you waive formal reading of the indictment?
We do.
Mr. Hurd, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
There are none.
Do you understand you are entering a plea of guilty to the following offenses? Aggravated assault with a minimum of 3 years and a maximum of 20. The recommendation would be 5 years to serve 46 days with the balance probated. And count 2, possession of a firearm during the commission of a felony with a mandatory 5-year consecutive sentence with a recommendation of 5 years suspended. The special conditions would be to complete family violence intervention program, complete 50 hours of community service, have no contact with the victim, Keisha, Keisha, Beckles, Beckles, and stay away from 50 Mount Zion Road, Atlanta, Georgia. And, Your Honor, it has been negotiated that the state would also not be objecting to first offender or a 3-year bid date. Is this what was explained to you by your attorney?
Yes, ma'am.
Do you understand? Are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum sentence on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if you do not accept the court's sentence, you may withdraw your plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Are you on probation or parole for anything, anywhere?
No, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation, even if sentenced pursuant to the First Offender Act?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pled guilty or nolo to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on your first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you further understand if your first offender is violated and you receive a conviction in this case, because it is a family violence, because it would be a family violence conviction, if you are found in possession of a firearm, you could be charged federally?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of aggravated assault and possession of a firearm during the commission of a felony in indictment 25 SC 003287?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed to trial, the state would expect to show that on May 12, 2025, officers responded to 230 Cleveland Avenue in Fulton County regarding a domestic dispute. Upon arrival, officers spoke with Keisha Beckles, who stated she was assaulted by her live-in boyfriend, Darius Hurd. She stated that earlier that day, Hurd and her were in their apartment located at 50 Mount Zion Road, also in Fulton County, when Hurd pulled out his handgun and pointed it at her mouth while calling her a ugly bee. Beckles stated there was no argument preceding this, but Hurd has done this several times to her. This time was the first she called the police. Beckles stated after he pointed the gun at her, Beckles made an excuse to leave the apartment to get some cash out, and when she arrived at the check cashing place on Cleveland Avenue is when she asked the clerk to call 911. Hurd and her had been dating for 4 months and living together for the last month at the incident location. Warrants were then taken out for Hurd, and he was later arrested on May 14th of 2025. And Your Honor, our office has had the opportunity to speak with Ms. Beckles, and she stated that she was not one to judge, but she did know that she wanted absolutely no contact with the defendant, and she wanted him to stay away from her.
And the apartment is her apartment rather than his?
Yes.
Okay. All right. Appreciate you sharing all that. I don't think we've gotten, oh, Ms. Jackson is on. Hey, good afternoon, Ms. Jackson. How are you?
And I'm sorry, Judge.
Oops, hold on one second, Ms. Jackson. Yes.
One thing I did want to add, and I don't know if the defendant will address this also, but there are, at the time, at least when our office last spoke with her, there were some things that the defendant still had at her home. She does not have a problem with the defendant getting them. She just wants there to be a police escort when that happens.
Okay, got it. We'll see what they ask about. Good afternoon, Ms. Jackson. How are you?
I'm great. How are you, Your Honor?
All right. Sorry if we didn't give you the right notice. This calendar was supposed to be at 9 this morning. We moved it to 1. But we've got a couple situations where we're definitely going to need your input. And this is one of them. Do you have the trial calendar? Oh, this isn't. This is more complicated. This case is not on the trial calendar.
I have the GCIC though, and I can at least give that.
Okay. If I give you an indictment number, are you able to check on the case?
Miss Nelson sent me the case number and I was able to pull it up, Your Honor.
Look at Nelson and Jackson working together like that. The main question I've got, well, obviously how many cycles, but Mr. Hurd is asking to be sentenced as a first offender, and I want to know if he qualifies for that.
Okay. He appears to. There are 4 cycles. The last arrest was February the 1st, 2017 out of Decatur, Georgia for aggravated assault and simple battery family violence. There was no disposition for that arrest. He does appear to have 1 misdemeanor conviction that was in 2015 out of Cobb County for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Thank you. And can I, just so that the lawyers who are working on another case keep working on it, ask you about one other defendant from the trial calendar?
Okay. And what position is that, Your Honor?
Actually, it's positions. He's been a busy guy. 11, 12, and 13. Well, it's all the same booking number.
Mr. Martin?
That's the guy.
Okay, if I could have a few minutes to pull him up.
Great. I'll come back to you when we finish this plea, just so we can get that nugget. Thank
Thank
you.
you.
All right. Mr. App.
Your Honor, good afternoon again. Thank you. As you heard, Mr. Hurd is 32 years old. He graduated high school at Douglas County High School. He attended college for a couple of years at Atlanta Metro State. He's got no prior felony convictions. There was a prior aggravated assault. I made sure to sort of look into that. It was null prost. He lives with his grandmother. His mom is here in support of him. He'll just stand up. He has family that supports him. He works full-time at a staffing agency, Your Honor. And so we are humbly, respectfully asking the court to accept this negotiated recommendation under the First Offender Act and with a 3-year bid date. I do believe the state has no objection to the court sealing his record today. If the court would consider that, he would be very appreciative because that would help with employment. If he wants to and needs to change jobs and sort of better himself. That's really all I have, Your Honor. We're asking the court to accept the recommendation. The only other issue is he's been on bond since he was arrested back in May of this year and been on an ankle monitor and had no compliance issues. And I'm assuming that would be removed after today with this plea.
Yes, I'll get to that as well, but that is be a natural, happy byproduct of the plea. All right. Mr. Hurd, do you have any questions about anything we've discussed?
No, sir.
Tell me what you do. I understand you work through a staffing company, but is it staffing where you work at a hospital generally, or it's construction, or what is it?
It's a warehouse.
Warehouse?
Yes, sir.
How often are you in a different role?
It just depends on the assignment. Sometimes it could be months. Sometimes it might be a few weeks.
Okay. But sometimes it can be a bunch of months.
Yes, sir.
Okay, but that doesn't turn into a full-time gig? It's always through the staffing company?
It depends on if they want to hire you. Sometimes they do that.
Yeah.
If they like you. But
Okay.
He has, Your Honor, not sought other employment because of the ankle monitor issue in the pending case. So
Okay.
that's
Well,
sort of.
we'll be clearing that up. Without an ankle monitor, and if this case is sealed, what kind of work are you hoping to be able to do?
I kind of thought about firefighting before, different stuff like, you know.
Okay. And you live with your grandmother. How long have you stayed there?
Well, I've lived in different areas. I just recently went back because of this situation. So I've been back there for like a few months.
Okay.
So,
Do you have any kids?
no, sir.
And Ms. Beckles, how did you meet her?
Work.
At a warehouse?
Yes, sir.
Okay. And you understand that she's going her way and you're going your way?
Yes, sir.
Okay. Has she tried to reach out to you at all since this happened?
I have text messages of her telling me to come back to the house the day I was arrested, but that's it.
Okay.
But I didn't see him until I got out of jail because, you know, they cut my phone off.
Okay.
So she had texted me telling me to call her and come back to the house and stuff.
All right. But you did not?
No, I didn't.
Okay.
He's
Good.
had no contact with her, Your
Yeah, I
Honor.
haven't talked to her since I got the ankle monitor and everything.
Got it. Okay. First offender is something you qualify for. It's an opportunity. It's generally a good thing. It means that it's not a conviction. When you leave here today, you're going to have a sentence, and it's a sentence that lasts for a while, some probation, some suspended sentence. But as a first offender, you're not a convicted felon. So when you're applying for work or looking to do other things, there's that question on an application, you do not have to check the box that says, yes, I'm a convicted felon, because you're not. That's one of the benefits of first offender. Also, if you successfully complete your sentence, it can all sort of be wiped off your record. The downside is that if there's something going on in your head, in your life, that causes you to pull guns on girlfriends and point guns at them, which suggests maybe you're not doing real well in some ways, you get arrested again. Not only would you have new charges, but you'd come back here And we'd need to work through, oh, was first offender the wrong idea? And without a trial, you'd have a hearing and Mr. Apt could help you with it. But with a pretty low burden of proof, the state could ask me to take away your first offender status and resentence you. And in this case, it could be up to 25 years. I'm not saying I'd lock you up for 25 years, but I am saying this. If you and I are together again in court and there is credible evidence that you had a gun, period, in your car, in your bag, in your house, even worse, in your hand, I will revoke a bunch of your time and I'll take away your first offender status. So you'll be a felon and you'll go down the road for a long time. I don't say that to scare you in any way. That's not my goal. It's just to let you know there is a risk to first offender. There are all sorts of benefits, but if you're not sure, you can be away from the guns and treat the important people in your life in a respectful and safe way, then first offender might be a bad idea. But if you think you've got things under control, then I will sentence you as a first offender. What's your thought on that?
I appreciate that, and you won't see me in here no more.
Okay, well, I don't mind seeing you if I see you because I'm at the warehouse and you're at the warehouse.
Here, you're not gonna
or you're coming to my house to put out the fire. That's a good thing.
Yeah.
I'm good with that. All right, Mr. Hurd, I find there's a factual basis for your plea. That your plea is knowing and voluntary. That means you've understood what we talked about. No one forced you to enter the plea. You agree with that?
Yes, sir.
Mr. Apt, can someone in my office sign the indictment on your behalf?
Please do. Yes.
And Ms. Willingham?
Yes, Sean.
Mr. Hurd, can we sign for you? Put your name electronically on the indictment?
Yes, sir.
We'll do that. I will sentence you as a first offender. Your sentence as to count 1 is 5 years to serve 1 month with the balance on probation. Count 2 has to be consecutive, will be 5 years, will be suspended. So the total sentence is a month in custody, followed by 4 years and 11 months on probation, followed by 5 years suspended. The one condition of your suspended sentence is that you obey the laws of Georgia, the 49 other states, and the United States. The many special conditions of your probated part of your sentence are, number 1, complete a family violence intervention program, and I'm requiring you to enroll in that within the first 3 months of probation. The course actually takes a while. It's not 1 class or 2. It's a series of classes. You've got to get started within the first 3 months of probation. Number 2, you have to complete 50 hours of community service. I'm requiring that those be completed in the first year of your probation. No contact with Ms. Beckles. Stay away from that apartment on Mount Zion. And I will set what we call a behavioral incentive date of October 17th of 2028, 3 years from today. If you've done your family violence intervention program, your community service, you've stayed out of trouble, Ms. Beckles hasn't been hearing from you, then we can just close all this out. You'll still have that suspended piece, which basically says stay out of trouble, but otherwise we can shut the case down. Any questions about that?
No, sir.
Ms. Willingham, anything else?
No, Your Honor.
Mr. Apt, I'm not averse to sealing, but I don't have a button that I press to do that. So if you want to file something that includes don't file the proposed order, send the proposed order to Ms. Nelson. I'm happy to take that from there.
I will email over a proposed order to Ms. Nelson and I will copy Ms. Willingham. And then, Your Honor, just to be clear for the record, the 1 month that he serves in custody, he gets credit for the time he already served. And I believe by my calculations, he already has 46 minutes. So he will have served that time already.
We're at 48 in the official record book, but both numbers are more than 30. And he is statutorily entitled to credit for that time. So you're not going back into custody unless you get arrested again for something else. And then we got to work through that whole first offender thing. So I wish you luck going forward, Mr. Hurd. Leave Ms. Beckles alone.
Thank you.
He'll get the ankle monitor off.
Oh, I forgot to mention ankle monitor, and Ms. Simpson, who is with probation, needs to talk to you about reporting instructions. Ankle monitor first. You need to get from Mr. Apt, which he'll be able to get electronically, if not today, then tomorrow, what we call your final disposition. That's your sentence. You take that to Second Chance. I don't know where they are. You'll figure out where they are, but they have an office. You go to them, you show them the final disposition. They get that magic claw that removes the ankle monitor and you're good to go. But you need to bring that paperwork. Don't just go in there like, dude, I've been sentenced. It's all good. you need to have the paperwork. Okay?
They're not gonna
Okay.
take it off.
They're not? Why?
I'll send you an order. They want an order.
They want an order? I'll tell you, Your Honor, I will submit that proposed order for the sealing of his record to include that the ankle monitor be removed.
So one, take your rain clouds elsewhere. But two, I know it's good to know, and I need to reach out to Second Chance because the final disposition should be enough. I have not ever entered an order to remove it, other than modifying bond, so before disposition. And I haven't had lawyers coming back saying, my guy still got his ankle monitor. I'm not doubting you, but we need to clear that up with Second Chance because the protocol is final disposition or order, or order, not both. That's just extra paperwork. But I'll do it. I will send it. I'll sign it. But I'm gonna then behind the scenes talk with Second Chance to try to clear that up. So bring both. You're gonna have an order that says take off the ankle monitor, but bring your final disposition as well. Okay? All right, Ms. Simpson.
Zip code.
30331.
Is it 30?
331.
331.
Yeah, 30331.
So your reporting date is going to be October the 24th. And you're going to report to 276 Memorial Drive, that's here in Atlanta. You need to make sure you be at the office at 9:30. And then I need to get with you to take some additional information.
She'll step outside. It's just gonna be all the contact info so probation can track you down. But word of advice, don't make them track you down. Make yourself available. So call your officer, report when you're supposed to, so that you are an easy person to find.
And I've told,
Yes, sir.
Your Honor, I've told him what I've told everybody that I represent for decades. It's not just that he can't possess, custody, or control a gun. As a precautionary matter, don't live in a house where.
Oh, yeah, your
Also has a
household
gun.
can't, if your grandma is a gun collector, she needs to decollect guns now, or you gotta move to somewhere else. You cannot be in a household with firearms in it.
And I've told him,
Yes,
so
sir.
he wants to go to the movies. Are there movie theaters still anymore? He wants to go to a restaurant and his friend who's driving him has a firearm, not to get in that car, to begin to make sure.
Yeah.
Because,
It's just safer that way. So you'll sort it out.
Yeah.
All right, thank you, Mr. App.
Your
All
Honor.
right, thank you.
And Judge, just so you're aware, not involving that case, we did get approval on, the diversion.
For Mr. Wallace's case. Well, how'd you know that?
Because me and Mr. Peoples were.
Oh, trying to make it happen. Great, but that's a Ms. Williams case.
She's on the
Okay,
email, so she's aware.
Great.
She's working on the other.
that was fast. Thank you. Okay, all right. Ms. Jackson, did you get a chance during these other conversations to look into Mr. Martin's situation?
Yes, sir.
And tell me about his criminal history.
There are 6 cycles. The last arrest was January the 4th, 2024, out of Florida for grand theft. There was no disposition for that arrest. He does have 1 prior felony conviction that was in 2009 out of North Carolina for possession of marijuana with the intent to distribute. And there is 1 misdemeanor conviction that was in 2017 out of Clayton County for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Thank you. Ms. Kurt, were you able to hear that?
No, and it was the 2009 one that I'm.
Yes, it shows in his NCIC that he has a felony conviction out of North Carolina for possession of marijuana with the intent to distribute.
He did not understand that to be a conviction.
NCIC understands it to be a conviction.
I understand. It's been ambiguous.
Well, what I'm getting from pretrial is not ambiguous.
Okay, I hear. Can I go talk to him?
Sure, of course. We can do,
Wait.
well, we can't, if, you should go talk to him. And if that's ready first, we can take that. We can do Way if we get Mr. Way and, Ms. Rockwell in here. Good afternoon.
Hello, Mr. McBurney. Yeah. Want me to come up?
Nope, Only if we get Ms. Rockwell in here. I don't want you standing there unattended. You're back. Okay.
I left at 1:49.
Yeah, the one.
So 1:49 is good. That was the stage.
We're good. Come on up.
That's 1:40. You know, it's on. Right, back. Yeah. That's all.
Judge, I just confirmed with Mr. Wallace, his client is gonna accept the version. We'll get you the proposed order, but are they good to go there?
They are good to go. Thank you.
I don't know. I think it's.
Judge, that concludes my business. Have you?
Yes, and thank you for helping coordinate that quick turnaround from diversion. Have a great weekend.
And Judge, I didn't want to say anything like never underestimate the power of greed or anything like that. I did have a client that did that with his final disposition. And while he had an ankle monitor for his bond, he also had a problem with probation. Then they wanted him to wear an ankle monitor and it was a big mess. So
Okay.
you can put it there on your line of things that I always take copies of, like address changes. You need to do a Daniels book. How are you?
40-6, that's 180. She got it.
Send it.
You bet.
Right, thank you.
See ya.
And Madam Prosecutor, you still want the theft charge?
Yes.
Glasses.
Oh. Did you go in the back?
What did you lose?
Like readers, but I will.
Your
I will
readers.
make do.
I'm sorry.
But thank you.
Miss Simpson, the ones on your shirt?
The one's right here. Okay.
That's funny.
That's terrible.
All right, Ms. Davis, are you ready?
Yes, Judge, I'm ready.
All right. This is position 17 on our trial calendar, State versus Rontaz Way. Mr. Way is here with his lawyer, Ms. Rockwell. We've got Ms. Davis for the state, and my understanding is that we have a plea. Is it a negotiated plea? Largely negotiated, not at all
We're a
negotiated?
couple of weekends apart.
Okay, it's a plea, and we can do that. Mr. Way, you have sat through a bunch of these. Ms. Davis will put you under oath, ask you some questions. You need to answer those truthfully and completely, and you need to let me know if you've got questions of your own, okay? All right, let's get started.
Mr. Way, please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name for the record.
Rontaz, Rontaz, Jacoby, Way, W-A-Y.
At this time, are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
43 years old. And I went to the 12th grade, but I have a GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses in indictment 24 SC 002478, theft by receiving stolen property, possession of a firearm by a convicted felon? And Judge, we are moving to amend the charge from failure to yield a right-of-way to a basic rules violation. And that statute is 40-6 -180.
I'm curious why that'd be the last one on there that I would think you would change. Does it have something to do with driver's license?
Yes,
Okay.
it's my understanding that's a part of his job.
Okay, so the two felonies are unchanged, but this little misdemeanor is switching because it has driving.
Implications,
Okay.
potentially.
All right, so the new statute is 40-6-180.
Correct.
And, Madam Prosecutor just wouldn't budge on the theft by receive, and so.
Okay, she doesn't have to budge on anything. I just was
Understand.
curious about this one, but I get it. I see the
That
shirt
was
says
it.
transportation on it, so let's keep going.
Okay. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Rockwell, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
Okay.
I don't think so.
No, ma'am.
If you have any questions, though, we can deal with them any time during the plea.
Are you satisfied with her services?
Yes, ma'am.
Attorney Rockwell, do you waive formal reading of the indictment and any and all defects therein for the purposes of the plea?
So waived.
And Judge, I just want to call attention, there is I'm going to call it a scrivener's error in count 3 with regard to the case number that is listed. The actual correct case number should be 15 SC 136069.
Okay.
Mr. Way, do you remember having been arrested on these charges?
Yes. Yes, ma'am.
Your Honor, the state's unaware of any outstanding warrants related to this matter. Attorney Rockwell, are you aware of any outstanding warrants related to this case?
I'm not.
Mr. Way, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
For theft by receiving, it is a 1 to 10 years. For the basic rules violation is 12 months. And for possession of a firearm by a convicted felon is 1 to 10 years.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you're pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by you or by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you be guilty of a felony which can carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And I'm going to go over 9 and then ask, do you understand? Okay.
Yes, ma'am.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charge to file a habeas corpus petition
challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 24 SC 002478, theft by receiving stolen property, possession of a firearm by convicted felon, and basic rules violation?
Guilty.
And Judge, we're going to just ask that on the theft by receiving, that the court take that one as an offer plea, and we'll speak to that at
Okay.
some point.
Got it. Now that I see what was stolen, I think I can see why there's going to be some confusion about it, but we'll talk about it. But it would be offered as to count one, straight up guilty as to the renamed failure to yield right of way and being a convicted felon with a gun.
Yes, sir.
Got it.
Okay. I thought maybe you were considering a NOLO to the traffic just to be safe.
No, not to the basic
You're okay?
rules.
Okay.
No need for
Okay.
that. Thank you so much for the amendment.
Mr. Way, has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter this guilty plea because you are in fact guilty?
Yes, ma'am.
With the caveat that on the theft by receiving, it's going to be an offer plea.
Understood. Is this plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Okay. Your Honor, the state believes the evidence would show that on December 15, 2022, that an officer with the Atlanta Police Department initiated a traffic stop on the defendant, Mr. Rontez Way, at 35 Hamilton E. Holmes Drive in Atlanta, Georgia, in Fulton County, Georgia, in regards to the defendant failing to yield as he accelerated out of appears to be a parking lot. The officer initiated a traffic stop and smelled the distinct odor of marijuana. The defendant admitted to having previously smoked marijuana before driving. The officer then conducted a probable cause search of the vehicle. At that time, the officer did not locate marijuana. However, he did locate a silver fully loaded Smith & Wesson .38 revolver. That revolver did come up as being stolen. Mr. Way is prohibited from being around or possessing a firearm as he is a convicted felon. The state's recommendation for Mr. Way, and his defense attorney has presented a lot of mitigating information, but we are recommending Mr. Way to serve 7 years, to serve 25 weekends. Mr. Way did serve 100 days in custody, but we're asking for the weekends to be in addition to that. The balance to be on probation for him to forfeit any firearms, the firearm in this incident, or any firearms that are in his possession, to complete 40 hours community service, and to have no further violations of the law.
All right. Mr. Way was arrested this month for having a gun.
Yes, Judge.
Did you know that?
I did, Judge, and defense counsel has shared with me some, I guess, potential mitigating information. But I'll let her speak to the court.
So while out on bond for don't have a gun, he got arrested for him, another gun. Okay, we'll talk about that. One second. All right. Ms. Jackson, in terms of criminal history, I have the repeat offender notice that's on file that lists 6 felonies. A lot of them are pretty old. If you could tell me how many cycles and the last arrest.
There are 42 cycles. And the last arrest was February the 8th, 2018, with the city of Atlanta for a failure to appear. The underlying charge was gambling.
All right. I don't know how you collect your information. Do you have the felony convictions listed chronologically? I can ask that question in a different way. The felonies I can see here on this form, a lot of them are old. There is one from 2016 from Cobb County.
Yes.
And I'm wondering if there's anything more recent than that 2016 conviction.
No, sir.
No. Okay. Thank you so much.
Yes, sir.
One.
More recent?
No, it's just 2017. It's a 15 SC case.
Oh, it's a 15 SC.
From Fulton.
Oh, that would be the one that's in this indictment.
Oh,
Is
sorry.
Mr. Way on probation? No? Okay. And the 2017 conviction, that's a 15 SC case, is for what? Oh, right. That's what it says in there.
Yeah.
Okay. Cocaine. Okay.
Yeah, but that didn't happen.
So Ms. Rockwell.
Uh,
I had to plead to that because I didn't have.
I understand. I just, making sure, Judge, we've had some difficulties with the record because he's a repeat offender.
He is.
He's two names. When you run his name, there's another name that comes up, Dodricus Hughley, which is a person, which is another client of mine.
Oh, right. We've talked about this before.
And he's
Right.
got court in front of Judge Mather on this coming Monday, so
Okay.
that person exists.
Yeah.
Another person that he often, it's just blended. When you put his name up at the Fulton County Jail, you get all kinds of cycles, and that person's name is
Aldridge Palmer.
Aldridge Palmer.
Okay. The person I'm really interested in is the person who was arrested 2 weeks ago for having a gun. Is that this person or is it Aldridge Palmer?
That is this person.
Okay. Let's talk about that first.
Can I bring you this at some point? You can be looking
Okay.
at everything.
Sure.
Madam Prosecutor has the copies that were sent to her.
Okay. Thank you.
I wasn't there.
We're talking about,
You want to talk about the new arrest?
yeah, on October 8th. So
And
1 week ago, arrested for having a gun.
Correct, and then he missed first he had to go to the hospital, then he went to the jail, and he missed his final plea, so. Initially, and when we discussed that, I certainly had enough time to try to get everything together and do attempt to do a global resolution, waive an indictment, et cetera. After my research, I am just concerned as to who actually possessed the gun. There might have been some talk, at least his father was involved in speaking to somebody at the scene as to whether or not his son was really in possession of a gun that might have been found on a bus or.
So what it says in the warrant affidavit from the officer is, I, Officer Smith, I show up at the scene, person shot, call, that's scary. He talks to your client. Hey, Mr. Way, tell me what happened. I just got out of the shower. I grabbed my tank top. My gun must have been tangled up in my tank top and it fell on the floor and went off. And Mr. Way is actually the person who was shot in the leg. You're gonna get to talk about this, but what this officer is saying, who's got no stake in this, is that Mr. Way is talking about his gun. And it's bad news that it went off and someone got shot.
Yeah.
I'm focused on my gun as a convicted felon on bond for don't have a gun because you're a convicted felon.
And
So that doesn't say anything about his dad or his grandpa or his son. He's telling the officer, my gun.
And he did tell the officer that the gun belonged to him.
Okay.
So I'll leave it at that. I did not want to give advice to his father regarding what the child. It was not anything that I thought I needed to waive indictment on and try to do a global, based on what I heard that night. Not from Mr. Way, but from another individual was there. I didn't even want to talk to the son because his son is 21. Didn't want to give any kind of appearance that I was representing the son to give him legal advice. None of that. So much like the Davion Hayes case where he had the revocation and the new case, where we could have maybe tried to get everything together, I'm asking the court to allow us to resolve this case just based on what I appear to be a very complicated situation with other people giving me information that certainly sounded like, I don't know if Mr. Wade was throwing himself on the sword.
Okay.
But he was here when you talked to the young man that wants to be a fireman. Can't be around a gun. I don't care if somebody
I'm
brings.
sure Mr. Wade's been told that before.
Right,
There's
right.
nothing magic about what I'm saying. It's probably sounding like a broken record to him that isn't
understand.
sticking real well.
I
But
understand.
tell me about this case, which is old.
It is, and what I rarely have is the occasion for the boss man to come in. So we, everybody gathered this morning, we didn't realize, and I've got Mr. Romiko Grant, who is actually the head of the department over there in the city of Atlanta. I would like for him just to address the court very briefly. Where would you like him, Judge?
Up by you. Everyone's on bond, so he can come and stand on your other side. Mr. Grant, you work for the city of Atlanta?
Correct, sir.
Okay, and you are Mr. Way's supervisor or the supervisor of his supervisor? Where do you fall on the chain?
Oh, yes, I'm like the supervisor.
Okay, and Mr. Way has worked for you, the city, for how long? 7 years. Okay, and were you aware of some of his run-ins with the law while he was working for you?
Yes, sir.
Okay, and he is welcome to come back and work for, I say for you, I understand it's for the city, but to work under your supervision.
Correct.
Tell me what kind of hours he works or days of the week.
We have a fluctuating hours of service, we deal with numerous things, so everything's pretty much in a fluid situation with us. We on call 24/7.
Okay,
So we respond to whatever, if it's a water main break or when you guys request barricades in front of you guys, for room for high profile cases.
right, and we never request them. The sheriff does. We'd like to keep traffic flowing. The sheriff likes to block traffic, but he's doing his job and keeping us safe.
Like we working like a fluid situation, so he's on call 24/7, so to speak, if they're about to say so. So yeah, he's a very vital piece to the operation. And yeah, he's been there 7 years, and he's been a model employee for the city for the last 7 years. And we're in this situation now.
Okay, well, you aren't, he is. Got
I
it.
feel like I'm with it. I just feel like I'm with it.
No, I appreciate you being here. It says a lot to have not just a coworker, but a supervisor or a supervisor's supervisor. And what you guys do is important. We have someone else here who's raising his hand.
And his father.
Oh, all right. Mr. Way, sort of senior? Okay, all right. Question though, Mr. Grant, if Mr. Way needs to be away from work on a fairly regular basis, what is the least disruptive? One of the things that the state has recommended is that Mr. Way spend some weekends in custody. And weekend to me, not on 24/7 call, is Saturday, Sunday. It don't have to be that though. I work with defendants who say, look, the way my work is, could I have Wednesday, Thursday as my weekend? That's fine. That's 2 days where you're going to be reflecting on different choices to make in the future, et cetera. And so I'm going to be asking Mr. Way this in a minute because it's his life, but you've got that supervisory view of if I'm going to be missing Mr. Way for a little bit, for a few weeks, I would like it to be these 2 days in a week. And what it can't be, unfortunately, is fluctuating like your work is, because it needs to be locked in so that probation knows and the jail knows this is when Mr. Way is showing up, so that if he doesn't show up, they let me know.
Be a consecutive.
Well, I'm going to talk to Mr. Way in a minute about, you want to just get this out of the way all at once? In which case it would be, you're going to go now or turn yourself in on Monday, and it's going to be X weeks. I don't know. I'm going to work through that. I need to hear more from his lawyer. She has a chance to say it should be 0. The other approach would be what the state has recommended, which is thinking that he has a 9 to 5 Monday through Friday. We don't have to interrupt work at all, because when he's not at work, he's going to be down at Rice Street Saturday, Sunday. He'll have these timeouts, but Monday morning he's back on the job. And so I'm interested. You're not deciding it for me. Don't worry. He's not going to be, Mr. Way is not going to be all fuss at you. But I'm curious because he seems pretty focused on this job. I got these letters and certificates. What is least disruptive for your?
We work on weekends as well, you know, it'd be like an alternate, consecutive ordeal that we would schedule around, like in the midst, but yeah, he's kind of like, you know, our go-to guy as far as like operating all our equipment, taking everything at consideration for people out in the field.
Yep.
Yeah, it'll be a tremendous impact if he's not there. Like, if I know he's not gonna be there weekend, I can always schedule the next week.
Okay. And what happens with vacation? Let's say Mr. Way wins the lottery and you got a girlfriend?
No.
No? Boyfriend?
No.
Okay, I just check. Significant other. He and his significant other are gonna go to Hawaii for a week. Can he get a week off, or people don't get a week off working for you?
They do, I would like, at least 30 days.
All right, getting notice as well. I'm hearing you say is, hey, if I can know, I can try to cobble around it. Okay, thank you. Back to you, Ms. Rockwell.
Yes, Judge. You have heard he is 43 years of age. He was born in Atlanta. He went to West Fulton, also Douglas High, did get his GED. He is not married. He does have 3 children. His 22-year-old daughter, his 21-year-old son, and I have presented to you, he's got custody of his 11-year-old child. He went to school for brick masonry, and somehow somebody, because his record's not good, somebody gave him a chance at the city of Atlanta. And he operates a vehicle, a big vehicle, the big heavy equipment. I want the court to know that there was never COVID off time for them. They never slowed down during COVID, not at all. So when we were all doing Zooms, they were running around the city with the water main breaks, et cetera. I don't think he's on probation, parole, or any kind of suspended sentence. And he did spend from 12/15 of 22, December 15th of 22, to 3/29 of 23.
I got that, 104 days.
And so, that is, when it's at the Fulton County Jail, you'll ask people, how long were you in jail? And they'll say, 6 months, because maybe it felt like 6 months, when it was only 3.5 months.
That's still a long time.
But, I don't know. I don't know if I'm asking for too much to ask the court to give him straight probation. He's, you see some of the accolades, and the reason I was fighting so hard is because his as bad as that jail screen looks with other people that have been intertwined in his record, his driving history, I understand, is impeccable.
Other than whatever happened on December 15th.
Oh, right, and Madam Prosecutor has saved the day.
Right.
The reason I,
Final act.
Yes, and that's about all she said yes to, because I had a little grocery list of things that I would have liked for her to do. So I will ask the court, whenever you look at a gun, it's sort of, as opposed to a car that might have a punched out trunk or a broken window or the screwdriver in the column, it's hard to look at a gun and say that's a stolen gun. He doesn't need to have a legal gun or an illegal gun or any type of gun, or it even be around him. But I just didn't want a theft on this plea. But if his boss is here and still needs him, I appreciate the amendment on the basic rules that doesn't get turned in.
Okay.
Um,
Got it.
I want to talk about like with my daughter.
Okay, yes, and he does want to address the court regarding his custody
Okay.
of his child.
Mr. Ware, I'm gonna ask you a few questions first, and then you can share with me whatever you want to share with me, okay?
Oh, well, she's right here, so.
Yeah. So this situation from earlier this month, I'm not asking you about any of the facts, because that's an open case. Who knows where it's gonna go, with one exception. How is apparently you got shot. I'm not asking who or how. Are you okay? You walked up here and you seem like you're doing okay.
I'm all right. It's actually still in my leg,
What is it, thigh, calf?
my thigh.
Okay, but you got medical attention,
Yes, sir.
and the doctors they're not saying we have to amputate or anything like that?
No, sir.
Okay, all right, good. What do you want to tell me about and the gun from back in December of 22 that cost you 3.5 months in custody? Where did it come from?
Like I told the officer years ago, like when I was winging my way out the streets, here and there, I bought it from someone else.
Okay, so you bought it from someone. I mean, you paid money for it. It's not wherever it came from. You just know you bought it from this dude.
Yeah, I bought it from somewhere else, and as a protection aid, I didn't know it was stolen.
Okay.
But it wasn't to cause any kind of mischief or ruckus or use it against anyone.
Right, except it causes you, unfortunately, a whole lot of mischief when you get caught with it.
Yeah.
I was just curious about its origin story, and you told me, look, I bought it from someone. Okay. Tell me about your daughter.
My daughter, 11 years old. I had got custody of her last June. So every other weekend she goes with her mom.
I read this order, and she's allowed to be with her mom?
Yeah, but per the order, it says every other weekend.
Okay.
So per the order, she goes with her mom. If I can work any way around my daughter, because she stays with me, I would be so grateful.
Who is in your household now?
Me, my daughter, my son.
Your son is 21 or 22?
21, going on 22.
Okay, so the middle kid. And does your son work, or is he in school?
He works at FedEx and UPS.
Okay. And are he and your daughter close?
Yes.
You hesitated.
Yes.
Why did you take a deep breath first?
I'm just thinking about the work part. They close.
Okay.
But he's barely there.
He's busy.
Yes.
And she, as an 11-year-old, is in 4th grade, 5th grade? Sixth grade?
Middle school, yes,
okay.
sir.
Where does she go?
Coretta Scott King, Young Woman Leadership Academy.
Great. How does she get there and back?
School bus.
School bus. All right. Man, they're just loading the supervisors in on the Gentle case.
That's right, Judge. How you doing?
All right. And you all live in apartment 3E, you, your son, and your daughter.
Yes, sir.
She gets the bus to school and back.
Yes, sir.
Your hours are typically not late at night, so you're around at her bedtime, or who's around?
I'm generally there. If I work over, it's 7:30, 8:30 at latest. If I work later than that, my dad helps me out with her.
Okay. The gentleman who's here. And does he live near that apartment?
Across the parking lot.
Well, there you go. Okay. So you were in for a few days for this recent gun situation, also in the hospital. Who took care of your daughter?
My dad.
Okay. All right. Mr. Way, tell me what you see as the least disruptive approach to the piece of your sentence that's going to be custodial. One approach would be, let's just get it out of the way. Do it all at once. Another would be we break it into pieces. And Mr. Grant's helped me understand that more notice for him is better. You've helped me understand probably the most important piece is that there's one weekend every other week when you don't have your daughter. And so an approach would be, it's going to be a number of weekends, but we'll have it land on those weekends when you don't have your daughter, because then I'm not saying she's in a better place based on what I read about her mom in this, but she's not with you then anyway. She's with her mom. And so that's another way we could do it. What do you think will work best?
Well, the weekend that she has to go with her mom, I would see if my dad could have, transport her to her mom.
Mm-hmm.
That's basically it. As long as my daughter's squared away, I'll be all right.
Okay, that's your number one concern, as it should be. Is she okay? And you trust your son to help take care of her, but he's busy working 2 jobs.
He works 2 jobs. I actually haven't found his schedule for UPS because he just started.
Okay.
He works overnight with FedEx.
Oh.
So UPS will be during the daytime. I don't know if weekends will, if he'll do weekends.
I don't know when he'll be sleeping. What weekends, if I'm looking at calendar here.
So what's tomorrow? So as of Friday, has time with her mom this Friday. Every other Friday.
Every other Friday through Sunday?
Yes.
Okay. So this weekend is the 18th. Next would be with you, the
weekend.
25th, the weekend after. So like Halloween, she's with her mom. And then that weekend, she's with her mom. Okay. All right. I got it. Anything else you want to add?
I do.
Tell me.
I know I made a lot of bad decisions, but I have changed my life around tremendously for me to have my son and my daughter. I have a daughter that goes to North Carolina A&T. She graduates in December. I just want to be there for my kids. I can't apologize for having it's beyond that, but anything the court can do to grant me so I can continue on my life, I would be so grateful.
Okay. Well, I'm less focused on you feeling grateful about me as you being in a position where at age 43 and the proud and active father of the 11-year-old, you stop getting arrested. That's what you need to do, is you need to stay out of trouble. And that means, number one, clearly no guns in your household, because I don't want to hear about what happened last week, but there was a gun in the household and you got shot. What the heck? You could have died. Your dad, whoever was there, could have died. And don't talk about that situation. Just know.
No, I was just gonna say I'm fortunate to be standing here.
Yeah, you are.
That's all I was gonna say.
Okay. Amen to that. And yes, you had a bad past. Some of that is a long time ago. That was young, Mr. Way, and you weren't doing the right thing. Clearly you figured some stuff out. You got your supervisor to come in here and that's unique. That very rarely happens.
I mean, that's how bad Mr. McBurney, that
Judge, he's a judge.
It's fine. It's fine. Just keep going.
That's how bad, Your Honor. I'm willing to stay free. I'm willing to go the extra mile.
Okay.
And he also is a supervisor. He supervises.
Well, that's a whole lot of supervision they've got.
Well,
That's
I
like
mean-
they need to get rid of some of that middle management. That's where I'm about to pay my city taxes and they are too high. Now I know where they're going.
Period.
Yeah. Okay. Anything else?
No.
Okay. Well, Mr. Way, you have progressed a lot from what I bet it would be like interacting with you when I see the convictions from it was drugs, 02, 05, 05, 06. That was a different you, and you've graduated from that, which is great. Let's not slide back in that direction. You don't need that hustle. I'm not saying you're engaged with anything like that recently, but keep moving in the direction you're moving. I find there's a factual basis for your plea, that your plea is knowing and voluntary. Knowing means you've understood everything we talked about. Fair statement?
Yes, sir.
Yes, voluntary means no one's forcing you to enter this plea. Ms. Rockwell, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Davis?
Yes, Your Honor.
All right, and Mr. Way, can we electronically sign your name indicating your offered plea to count one? You didn't know the gun was stolen, but you acknowledge it was, and then your guilty plea to counts two, which has been modified to be OCGA 40-6-180, and then the possession of a firearm by a convicted felon. Can we sign that for you?
Yes, sir.
Okay, we'll do that. So what I am going to do is sentence you on count one to 6 years to serve 3 months with the balance on probation. You'll get credit for the more than 3 months you already did. So I'm not sentencing you to 3 months prospectively. Count two will be 3 months to serve. And count four will be 6 years to serve 3 months with the balance on probation. They're all going to run concurrently with each other. Special condition of probation number one is that you forfeit the firearm that was seized back in December of 22. Special condition number two is 40 hours of community service. Those must be completed in the first year of your probation. And special condition number three is that you are going to complete 12 weekends in jail. You will turn yourself in by 5 o'clock on Fridays. You'll be released by 5 o'clock on Sundays, but it's going to be alternating weekends, with the first weekend being not this weekend, unless you could make it this one. That's too soon. The paperwork's not going to be in the right place, so we're not starting then. So don't even try that. It's going to be easy to remember. Halloween. Halloween is your first Friday that you turn yourself in. This is going to be written on your disposition sheet. So it's 12 weekends, but it's every other weekend.
Okay.
The weekends you do not have your daughter.
Okay.
If something changes, hey, you know what? Her mom and I switched weekends, and you want to switch weekends, that can happen.
Okay.
But you need to, just like you're going to be letting Mr. Grant know, I can't be here on this day, you'll be letting your probation officer know, I'm switching weekends. Because they'll be checking with the jail. Did he check himself in? No, he did not. Please send me a warrant for Mr. Way. I'm telling you, if you miss a weekend without prior approval, or you show us, look, I was in the hospital, I shot myself in the leg again, that would be a problem. I dropped a fork on my leg. All right, that's okay. If there's not a good reason for you missing it, then we'll get back together and I turn each weekend into a week and they all run consecutively. So it'll be, if you had 10 left, we're just going to have 10 weeks in custody. That's going to disappoint Mr. Grant. That's going to be super complicated for your daughter. Your dad is going to become grandpa full time for weeks and weeks and weeks. So don't miss those weekends. But if you're gonna, just here's the doctor's note. I got to go back in because they're taking the bullet out of my leg. They just happen to be doing it on that Saturday. Okay. Then we'll move that weekend to the end of the line.
Okay.
Okay.
Thank you.
That's it. Any questions about any of that?
No.
Okay. My last word of advice is just no guns in the household. They cannot be in your household. It doesn't matter if it's your sons, your daughters, better not be your daughters, or your dads. They can't be around you. You see what happens. This case is old. I'm much more concerned, and the reason why the weekends are being tacked on here is because of this recent situation that happened. And if Ms. Rockwell can figure out a way to get that case in front of me, I'll have it end up the very same way. I won't. Chances are I won't be the judge on that case, but it's that situation that prompted me to add that piece on. Because otherwise, this was 3 years ago, and look what you've been doing since then. Work, 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 dad, all good stuff until a week ago. If you had pled this out a month ago, oh well. I wish you the best.
It would have been a warrant, probation.
I guess that's true. We would have been back together anyway. I feel very positively about the direction in which you're moving, and the fact that these gentlemen are here, that a judge said you're the right one to be taking care of your daughter. Those are folks you want to keep their support going. Okay.
Let me just ask one question.
We're always so close to being, and then like here comes the wrench.
I want to do this so I don't have to come back and do it again. Is it exactly every other weekend without fail? Some months have more weekends than other
Yeah,
months.
it's every other weekend.
without fail. Wonderful.
for your daughter. And that's how we'll do this. It's literally, we're going, I don't care what month it is, we're just going one weekend on, off, on for
If
12.
anything changes, I'll let Miss Renee know, my probation officer. I'm gonna let somebody know.
Okay,
that it
good.
won't be no warrants or won't be none of that.
All right.
After I leave this courtroom, I promise you that.
Okay. Ms. Simpson, who is seated right there, is with probation. She needs to give you some reporting instructions and you'll want to make sure you follow those. You don't want to miss that first date with your probation officer. Given your address, I can tell you that it will be here in Fulton. And so the probation office is right down the street, on Memorial Drive. Ms. Simpson?
30314.
Right, so your reporting date will be October 21st, that is this coming Tuesday. And you're going to report to 276 Memorial Drive here in Atlanta. And you need to report at 8 p.m. And I will get with you once we're finished this month.
Where does he report for his weekends, Judge?
Rice Street, just you go right into, or you don't go to intake. You can't go over there. What is he? Front lobby, like you're going to visit someone, and then they show you the secret door you get to go through. Okay?
If I work late Friday, 7:30.
But see, you can't work late Fridays, and that's where you.
Well, not the Fridays that I have to do that.
Right.
So
Oh, no, on your other Fridays, you work till midnight. You just got to get dad to take care of your daughter. But the Magic Fridays, for 12 of them, 5 o'clock, at Rice Street.
I understand.
Okay? All right. You got everything? We're all set?
One more thing on the record, in case I get hit by a car full of
Driven by
jail.
McAfee.
Yes. If you go to the Fulton County Jail and there's no paperwork, that is not manna from heaven. Okay? So we'll figure it out, okay?
Yeah, that's when you call Ms. Rockwell. If you show up and you're like, what? This is not a hotel. You can't check in here. Call Ms. Rockwell. She'll document it and say, Mr. Way went there and they wouldn't accept them and we'll fix it. But don't think, okay, I just took care of my weekend. They sent me away.
Oh,
Check.
I'm not gonna do that.
Okay.
Judge, could we have all of his accolades back?
Yes, especially the legitimation paperwork. So we're off the record. Ms. Rockwell, I have received word that Second Chance is supposed to act on file stamp disposition. So if they're not in that instance, you should let me know or someone and we'll fuss at Second Chance.
I've never in street name here in city and state.
Yeah, Judge, if last weekend hadn't happened, the weekend.
Yeah. Ms. Kirk, how are we doing with Mr. Martin? Close.
Uh-oh.
Keep talking. Okay. I'll be right here.
Thank you so much,
Do
Judge.
you need to list your files just in case your files are not?
Yes.
You were actually saved by, is it Sergeant Lattimore? What rank is he now? Lieutenant Lattimore, because he came into the crosswalk. We saw you and McAfee's like, I'm gonna gun it. And then Lattimore came and you guys were hugging and like, we didn't want to hit Lattimore. He's good people. So,
And so, Drew Finley's daughter was right there.
oh, is that who that was?
Yes, that's Samantha Finley McFoy.
Mm-hmm. Okay. Yeah, I've
I'm a
heard.
defender,
Okay.
and she's a
Firecracker?
diehard PD. I asked her, I said, you don't want to go work with your dad?
This number.
The $1 billion lawyer?
Right. I just need to. You're all set?
Thank you.
Okay,
That's
you
it.
good?
Thank you, Your Honor. I really appreciate you.
Good luck.
Like, take care of your son.
I don't know, it looks like all this time.
I don't mean if that's an option, I've done it before, I don't know if certain.
And if you need a supervisor, there are like 12 of them in there. You could see what's going on.
How are you?
I am eagerly awaiting the outcome of that surgical procedure you guys are involved with.
Aren't we all, Judge? Aren't we all?
Or I'm happy to see everyone Monday morning.
That's a thing. That's a thing.
You know how much she's had left, but she decided on vacation. Oh, okay. $18 and reinstated. Probation is February 13th.
Did they tell you, there is some good news. I don't know what the heck's going on with all that, but the pretrial diversion was approved. That's so fast. I'm glad you're here.
My colleagues are great, aren't they?
Well, it's a team effort and you led it. So I excused Mr. Bonilla Garcia.
Excellent. Mr. Denslow indicated he would be getting back on the Zoom.
Hello, Mr. Denslow.
Judge McBurney, how are you? Busy?
I never want to negotiate against you because whatever you were doing necessitated not one, not two, 3 different supervisory types had to trundle through my courtroom and go back there in the jury room. So my white flag is raised if it's McBurney versus Denslow. Fortunately, I'm not on either side of the V here. What are we doing? I have Ms. Williams standing right here. You can't see her, but she's in court. She's just in the jury box. And I've got you. So either one of you can speak freely about the case because the other side is here.
Judge, go ahead, Ms. Williams.
Go ahead.
Okay. Judge, we made a lot of movement in the case. I think that we are close to a resolution. The issue we are having right now is this. Not Miss Williams' fault whatsoever. This is beyond the 11th hour for negotiations. And unfortunately, while we've come to terms about just about everything, it is about what offense we are going to plead to and whether or not Mr. Gentle will be required to register as a sex offender. This is particularly important because where he lives currently is not registry compliant. And I am having a really hard time sentencing my 85-year-old veteran client with dementia to a situation where he may be immediately homeless. And because this is Thursday before the jury trial, I've not had a whole lot of time to be able to make arrangements for my client and his living situation, and frankly, make sure that he fully understands what the ramifications of the registry are. Now, him being 85 years of age, once he finishes probation, because there are no similar transactions, there are no issues as far as things that would prohibit him, we can then petition the court to have him removed from the registry as soon as he completes probation because he's over the age of 80. He's over the age of 80. Unfortunately, where we stand right now is I can't sentence him to homelessness. I'm trying to work this out. The state is unable to budge to something like a child cruelty that would not require registry. And Judge, I know you don't get involved in plea negotiations, but that is where we are.
Okay, so a couple thoughts about that. I'm hearing you, and I'm sure you're familiar with 11th hour plea negotiations, so that's not a novel concept. I don't believe that this would be an immediate homelessness situation, and I say that for a couple reasons. One, we could certainly go through with a plea, if not today, then Monday morning, because those are our 2 options. And I could withhold signing the final disposition until the appropriate arrangements have been made. Two, I'm not familiar with it ever moving so quickly that the moment I sign the final disposition, probation shows up and said, hey, you got to move. That is not me saying there wouldn't be complicated consequences if the way the two sides ultimately sort this out is that it is a plea to an offense that requires Mr. Gentle to register and more consequentially to relocate. That's significant. So I'm not minimizing that, but none of it is instantaneous. And one way to take the pressure off of you and his household to figure out where does that mean we'd end up would be to enter the plea, so that we know this is a case that's not going to be a trial and the state doesn't need to continue to prep the young man who would have to come into a court in front of lots of strangers and talk about something real awkward. It'd be awkward for your client as well. And we'd agree, we'll reconvene in a week to talk about, is it time to sign the final disposition and what are the specifics of it? It sounds like the general framework, not the charge, but the general framework, it's X years of probation, it's no contact with this and that. Maybe you all have sorted that out. I hope there's been something sorted out during the hour-ish plus that all these supervisors have been trying to sort this out. But those are my thoughts or initial reactions to your concerns. Why don't you respond to those? And then I'll certainly want to hear from Ms. Williams as well, because it's a two-sided situation.
Judge, I think that is an avenue we can certainly pursue. The fastest I've seen is 3 days after the sentence that they have been told by the sheriff that they must vacate, which is clearly not enough time. But it sounds like, Judge, if you were willing to do that, that is something that we would be amenable to. I will tell you that I would, while I have some things on Monday, obviously, that need to be addressed, I think Monday would be the day so that I have adequate time to make sure my client knows he's entering this plea voluntarily, all the boxes we have to check to make sure this is the only time we have to do it. But I do have a question for you, Judge, insofar as I'm not going to hold you to a specific time frame, but again, I don't know exactly what the situation is. Are we talking about 2 weeks? Are we talking about 2 months? Because that is going to be, there's some tension there.
Sure. I would need to have some pretty good explanations as to why it would be more than a month. But that would be the kind of thing we could talk about on Monday. And again, I need to hear from Ms. Williams, but assuming it's, yes, we're going forward with this, I can assure everyone right now, I'm very comfortable with the two-step process of let's see if it's a knowing and voluntary plea. Yes, it is to this count, these counts, whatever it is. And between now and then, the state can get an accusation together, assuming there's an indictment waiver, if it's going to be to something different from what's in the indictment, but that is still an offense that requires registration. That ought to be enough time. But I'm letting everyone know I'm open to the notion of all we do on Monday is take that plea, and maybe people get on the record some commitments that the state's recommendation won't be more than X and all that, so that you're locking them in, because a plea and there's no representation from the state as to what the recommendation is going to be. That's probably not what you're angling for. And then we could have the discussion on Monday about, well, when is our next meeting for the final disposition part? Is it in mid-November or is it in early December? It's definitely going to be in 2025. And my preference would be foreclosure for everyone, the victim and his family, for your client, et cetera, would be, let's get together in a month. But like I said, I am always open to hearing from both sides about what is most practical. Let me hear from Ms. Williams.
Thank you, Judge. First of all, I would like to thank you for being so patient. There was a lot going on back there.
We were doing other stuff.
And Mr. Denslow was very zealous for his client, and I appreciate that. Everything that he said is an accurate representation of our conversation. The charge is an issue and the registry component, just as he represented. And we are much closer than we were. I think that I will stay in close contact with Mr. Denslow. I'll make sure he has my cell phone, and I think we will be able to provide the court and Mr. Gentle with something firm and, as you said, locked in Monday morning.
So when you say firm, the things that have been happening today are bringing people closer together from the two poles of dismissed with apology and 20 years to serve. But it's still not, hey, we agree on X and Y and Z, but there's this question because the state is choosing to stay with a charge or charges that require registration. What I heard from Mr. Denslow is the main issue would be it won't work to have the immediacy of 3 days from now, the sheriff shows up and says, all right, Mr. Gentle, you got to go. And I get that. And I will ensure that that's not what happens. But what I also don't want to have happen is Monday morning, we all come together and people say it's not worked out, but because we thought we were going to work it out, we're not ready for trial. Because Monday morning is when jurors are going to be here, and they're going to be here for Mr. Gentle's case or Mr. Martin's case, but it sounds like maybe not Mr. Martin's case. And so then it would be just Mr. Gentle's case. And so as long as you guys understand, if it's not worked out, then we're picking a jury, then, okay.
Yes, Judge, that is absolutely my understanding, that if we don't come in here with a plea, then we need to come in here with 4 dire questions prepared.
Okay.
Judge
All right.
McBurney, that's not my understanding. And here's why. As the court, it was aware and brought up at the previous announcement, and this is Kim Fry for your court reporter. We filed a motion for continuance in the case, which has not been heard. We spoke to Ms. Williams about a continuance for the basis of us to be able to work this out. Because as you heard from the calendar call, you heard the same time that we heard that there was a new offer in this case. We got a new motion in this case on Wednesday evening. And so I think the situation that we're in, that's why you were presented with the continuance. My bigger concern is we have a much older case that is set for the Monday following. So if we start, Mr. Gentle, even if we start him at 10 o'clock in the morning, I'm doubtful, even despite your best efforts, that we will be finished by Friday, nor will we be ready on that older case on Monday that is going out in Douglas County, which is part of why you have your continuance motion in there. But also there's several things that we do not have currently. So no, it is not my understanding that if we do not get this worked out, that we will be ready to pick a jury.
Got it. Well, I'm happy to help you with that. You should change your understanding because I'm denying the motion for a continuance. And what we're doing on Monday morning is either resolving the case or picking a jury. I'm not familiar with any rules of conflict that say, I've got a trial a week later, so I shouldn't have to go out now. I don't know what the Douglas scheduling system was, but you've had this calendar and frankly, we're out first, older, newer, or the same age. I saw the other grounds in there. I am confident we can work through the state's 2 motions Monday morning while we're waiting for the jurors to get here. And we can sort out the school record situation as well. So, as I said, Monday morning, Mr. Gentle should be here in court with both his lawyers, one of his lawyers, no lawyers, his call. Ms. Williams should be here with Ms. Clark, without Ms. Clark, and we can take a plea. And we can take half of the plea along the lines of what we discussed, or if there's not a meeting of the minds, we can pick a jury. But that's what's happening in courtroom 8D with Mr. Gentle's case. He's on bond. There are consequences if he's not here, ready to go at 9 a.m. Monday morning.
Judge, just to clarify, I do understand what Ms. Fry was alluding to. So when we did speak in the back, Mr. Denslow did ask me, was the state opposed to the continuance? And what I expressed to him was that the state does not oppose their continuance to the extent that the court is amenable. So we would consent if the court would allow it. But my understanding is that that's sort of a moot point.
Right. Correct. This case from Douglas County, I assume wasn't calendared yesterday, and I got the motion for continuance today. So the tension between the two cases, schedule-wise, has always been there. And so even more 11th hour than your motions from the state would be the defense motion saying, oh, I've got this other case that actually happens a week after this one that's been on a published calendar for a while. And lawyers have conflicts. If the lawyers are stuck in trial here, they can't be in Douglas, and the judge in Douglas County understands that, and we'll have to move that case to another time. But if the lawyers for Mr. Gentle are not in trial in Fulton County come next Monday, then that following Monday, they'll be able to go forward with the Douglas County trial. But we're going to handle Mr. Gentle's case on Monday in whatever format the lawyers can sort out. Plea or trial, but it is definitely time. And I'll be prepared to talk about the state's two motions that were recently filed, and we'll go from there. Ms. Fry or Mr. Denslow, anything else on behalf of Mr. Gentle?
Judge, just this is more of a logistic thing, because there's been some issues where I haven't been getting served all of the orders from the court. Did you issue an order on the motion to quash that subpoena?
No, I don't believe I did. So I think that there was nothing in the motion for continuance that I disagreed with. I understand it. You got some Douglas County case a week after this one, and the school record situation is still floating out there. And there are, in fact, two motions from the state that were very recently filed. They're all navigable, and I know you'll be ready to argue them, and I'll have thought about them and have a perspective on them for the time we'll have on Monday morning before jurors get here, if the pivot of the group is it needs to be a trial rather than a non-trial resolution.
And Judge, what time do we need to report Monday morning ready for trial?
9 a.m. And I'll be sending an email out to, I say the three of you, Ms. Williams, Mr. Denslow, and Ms. Fry, because I actually need to get your proposed voir dire by midday tomorrow, because I do a little work over the weekend to get a trial packet ready, and I will be sending back to the lawyers probably late Sunday. Here are the general voir dire questions that I intend to propound to the jury as a large group before we break them into smaller groups where then the lawyers get to follow up.
So question, and this is only logistical because I've never done this in this courtroom before. So if for some reason we're able to come to an agreement for a plea, would we inform you via email or just wait until we walk in Monday morning?
No, email to Ms. Nelson is always welcome. You're welcome to copy me. I'm not a judge who says, how dare you communicate with me, as long as the other side is on it.
Yes.
And I trust you would always copy at a minimum Mr. Denslow. Ms. Fry is now getting in the mix as well. So copy both of them. But if I get an email from both sides saying we've sorted this out, then we can all not be worrying about getting ready for trial. But if just Ms. Williams sends an email saying, I think we've worked this out, and there's not a confirmation from one of Mr. Gentle's lawyers saying, yes, we have worked it out. And I want to be clear, working it out, it can be merely, and it's not insignificant, we'll be entering a guilty plea on Monday, but we don't want sentencing to happen. That is enough to say then we're not going to trial, because there'll be a plea and there's just not a final disposition yet, so that Mr. Gentle understandably has time to work through the logistics that flow from the consequences of a plea to whatever the charge is from the state. If there's not a change between now and whenever to, you know what, now it can be cruelty in the first degree or whatever some of the counter proposals have been from the defense. And I'll stay out of that dialogue, of course. But if both sides concur in an email or two saying it's been resolved, then it's not a trial. And then that Monday morning, we'll take care of it. I'm a realist and I'm going to have jurors ready for Monday morning. But I will trust that at the time you all sent the email, it in fact had been resolved. But while the state won't go back on its word, Mr. Gentle has hard decisions to make, and his changing of his mind isn't a breach of any contract or a moral failing on his part. He's like, you know what, I thought I would be willing to do this and now I'm not. And so we just would be scrambling a little bit more come Monday morning. But I will leave it to you all, and you should feel free to reach out if there are questions or, well, what about this? I will be available throughout the day.
Judge, I do have one, because
Already.
yeah, I know. Are you surprised at this point, Judge?
I'm not at all. I'm surprised it's only one.
It is, but
I have
while
one
you
too.
gave me the props of being the negotiator, I'm also a problem solver. And if you want me there Monday ready for trial, I don't have any choice, and I'm with that. That being said, since the court has not quashed my subpoena to the school, in effect, that subpoena is enforceable, correct?
Yes, sir. And
So I
so
will-
what would probably be best is if you conferred with the school and they got that to court Monday morning, counsel for them. And I'm fine. I know you've offered up well, you didn't offer it up, but as a middle ground, it's an in-camera review. I think frankly, that's the cleanest approach. But they still need to get them to me. And so if they're under subpoena, they ought to be there Monday morning. And it may be that I ask that the records go to me before you would get whatever is appropriate to get. But I'm following you.
Again, though, if it's not been quashed and it's enforceable, I want them to give it to me tomorrow so I can read them over the weekend and be prepared for trial.
Okay. If they'll give them to you tomorrow, go for it.
Got it. I just want to make sure I wasn't running afoul of an unwritten order. I just wanted to be sure.
Nope. No unwritten order. If you can get your hands on them tomorrow, you've got them tomorrow.
Fantastic.
And Judge McBurney, I know in some cases with Fulton County having a lot of cases that cases are sometimes presided over by another judge different from the judge that ruled on the motions. Will you be our trial judge next
Yes,
week?
ma'am. I will be the only judge in courtroom 8D on Monday morning. We do have a consolidated criminal trial calendar. I think Mr. Gentle's case may have been on it once, but it was premature that I put it there. I don't remember, but it doesn't matter. This is on my calendar. I'll be the judge. You guys will be the lawyers. It will not be Judge Emerson who handles our consolidated calendar.
Ms. Williams, you have my email address? I think we're on some emails in common. If you want to shoot me your phone number, we'll exchange numbers, and so we can keep talking.
Absolutely, we'll do that.
Thank you.
Sounds good. We'll keep Ms. Nelson and or me in the loop. I will move forward, assuming it's a trial Monday morning. In other words, I'll send an email out later today or early tomorrow saying, here's what I need in terms of voir dire and jury charges. And then I'll pause on that if I hear something to the contrary. Okay.
Oh, the only other thing we'll have to deal with Monday too. Now I'm not doing it on purpose, I promise. But Judge, we have to talk about maybe that's some of the work you're gonna do over the weekend, so we're all ready to go Monday. I think we had I can't remember now, which I'll have to go. I do have this transcript. I'll have to go back and look about. Oh, never mind. I'm sorry. You denied that. That was a different judge. Got more than one judge in my head. You denied the motion about the pre-preliminary charge, so we don't need to worry about that.
Right. Won't be doing that. Okay. Excellent. But I want to be clear, if questions come up between now and because, well, Ms. Williams hasn't had a trial with me, neither have the two of you. So if you've got questions, reach out and I'm happy to let you know how things go. It's a little different here than in some places. Jurors get to ask questions, things like that. Now's not when we're going to talk about that. We would talk about that on Monday morning. Okay.
Thank you, Judge.
And Judge, one last thing, we are missing that transcript. Your office has a little more power than our office does as far as facilitating getting that. If anyone in your office can assist us in seeing how quickly we can get that transcript from that second motion hearing, that would be helpful.
So Ms. Rivers is telling me she thinks it's ready. Which transcript are you talking about?
July 2nd.
Okay, let me look. Oh, come on, people. So it is in the docket of the old version of the case.
Okay.
Yeah, so the state's been filing stuff in the old version of the case as well. I think you have it because you're on e-file Georgia, but their motion to clear the courtroom when the young man testifies, I'm seeing it in the old docket. But the motion transcript for July 2 and May 9 are both in the old docket because when those were taken down, I think that was the indictment number. And so that's what the official record looks like. So if you go into just 809, not 809-01, you'll find those transcripts.
Fantastic. Thank you.
See, we're just here with answers.
Take problem solving. That's what I said.
Well, I don't think you solved that problem, but okay. Anything else?
Not
Nope.
at this time.
All right, you guys enjoy your weekend.
Thank you. Are we?
Man, you've been done for a while. Do I need to sign something for you? Thank you for getting that door too when Deputy Gordon was having a party in his office, whatever it was. Wasn't no party.
How are you doing? No, I was in the state of Atlanta and Clayton. Yeah, I was over there. I'm like, no, you. Okay, how you been?
I don't remember names.
Okay, faces it is.
People coming up to Clayton.
No,
Oh, I'm not going back to Clayton. The wild, wild west.
Your Honor. Your excuse. Thank you.
good luck.
Thank you.
Not all the cases are like this.
Sure.
You can come to Clayton.
Stop recruiting.
I see little people here from Clayton.
Yeah, you did.
I mean, yeah.
You still talking?
Yeah, that we were.
I think we're good.
We were ready, Judge. I don't know.
Can ask about the.
Oh, yeah.
Conditional discharge. Judge, are you trying to leave?
No, I'm just trying to figure, I'm standing because I've been sitting for a while.
I'm scared.
Nope, I'm good.
So my client apparently does not have a first offender abuse, but would possibly have a conditional discharge. I know there's 3 indictments, Judge, but really it's one case. There's one police report.
I'm seeing how they're all linked. I don't know factually how they're linked, but it's all the same booking number and,
One investigation.
yep.
One arrest, one officer, same witnesses. They just kind of, I think we're kind of trying to track down where everything came from, maybe.
But for sure, 2 of the cases are December 9th, and they probably should be combined. One of the cases should just be 2 misdemeanor charges.
And that was found on the same day as the
Mhm.
2 cars, so I don't know why it's a different date, other than maybe it took them a minute to get an answer from the DOR.
Right.
Where the tag came from.
What is the substance abuse angle to all this?
Sometimes smokes weed.
Okay,
Okay, I'm working good.
Okay.
I'm working
all right,
to close a case.
Yep.
With the fewest, because I do feel, she and my heart, there's no way that, if he was in college at the time this happened, Judge, the offense that is the prior.
the North Carolina one,
Yeah.
that's from way back when.
It's from way back, it was a small amount of weed in individual babies. It is something that would have never been a felony conviction in the 30 years that I was in Georgia for a young college student with absolutely no history. There would have been 8 million ways we would have figured out something different. And I don't know whether he had a bad lawyer or North Carolina's just mean that way, or whether
Or both.
it used to be mean, but now they're cooler and there's ways that could be cleaned up. For instance, now I could go back and ask for if it was in Georgia, I could go back and ask for a retro,
Active.
thank you, that word, first offender, and then that would be.
Right.
And so maybe there's ways to clean that up. I don't know, because it wasn't on this GCIC and I wasn't ever getting a
Right.
clear answer on it.
Right, because it wasn't gonna be on his GCIC, it was gonna be on the NC, and that's harder for people to get, so.
But still often out of states, I look at 300 GCICs a week, out of
Okay.
state stuff shows up all the time.
Okay.
It just didn't. At least when I'm prosecuting, that's what I see. I'm like, oh, look at you, you were colorful in your Texas days. I see it all the time, and it wasn't there, he wasn't listed as a felon in the little spot that
Yeah.
says this is a felon.
Okay.
He didn't think it was a conviction, and maybe it wasn't even a conviction, I don't know, I haven't seen a certified disposition. So I'm just trying to keep, if there's a way that he can go back and get that cleaned up, I'd like to have this be clean too.
Right. But if that went away, he could use first offender on this.
If it went away, but I don't know that it's going to, I don't know what is, but if you use conditional discharge here successfully, and then he was able to clean that up, then Judge, he's about to turn 40. I mean, look at him. Judge, does he look like trouble?
I just don't know Mr. Martin, and so.
I do.
Yeah.
I was actually, as I was talking, I'm like, why did they find a bag of cocaine in there? That would have
Made it easier.
But that's not his life right now, really,
Okay.
for real. But I like that, he's about to be 40, he's about to, he's really got a lot of good stuff going on in his life. I want him to be able to, like I said, if you're already like a hard convicted felon, then I'm always just shooting for probation. But if you're not really a convicted felon in the whole world, that's something I'll go down and fight for, because I know what happens after.
Yep. So, why don't we, start the process? I can learn a little bit more about Mr. Martin, and depending on how that goes, we can either do what I suggested to these lawyers, which is, why don't we take the pleas and then, set a kind of tight deadline, for people to figure out what is the North Carolina situation? Is it in fact a felony? I'm not doubting Ms. Jackson at all. That's not my point, but let's see what North Carolina coughs up. Oh, look at that. It is, a felony, or it's not even a felony, or it was a whatever. But I may, after I hear enough about Mr. Martin, be comfortable with the angle that you're suggesting.
Okay.
Okay?
Thank you.
All right, Mr. Martin, why don't you come on up, please? Can you, you're tall and the monitor is low. Can you angle? No, you don't need to move because I want you near the microphone. We're just gonna, there we go. All right. Thank you. Let me know when you're ready, Ms. Davis.
Ready, Judge.
Okay, let's get on the record in 3 cases, 25 SC 002194, 2258, and 2379. All involving Mr. Martin, who is here with his lawyer, Ms. Kurt, and we have Ms. Davis for the state. Mr. Martin, you've gotten to sit through a few pleas today, so you know what the process is. In a moment, Ms. Davis will swear you in and ask you a bunch of questions about you and your cases. You need to answer as completely as you can. If at any point you want to talk with Ms. Kurt privately, or you've got a question, let us know so we can work through that. Will you do that?
Yes, sir.
Okay, Ms. Davis?
Please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court will be the whole truth and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Azel Christopher Martin II.
Can you spell your first name for the record?
Azell.
Are you under the influence of any alcohol, drugs, or medication at this time?
No, ma'am.
Is there any medication that you normally take that you have not taken?
No, ma'am.
How old are you and how far have you gone in school?
49 and college graduate.
You're 39 or 49?
I'm 40. I just turned 40. My birthday was October 12th.
Okay.
So you're 40.
I'm 40. No.
Okay.
Gotcha.
Yeah, I was 39. I'm 40 now.
Got
I'm
it.
40.
Okay. I just thought your lawyer had shaved a decade off you. Like,
49.
wow, you're good for 50.
Okay.
Woo, I gotta
Yeah.
use what you're using.
Yeah, we all do.
No,
All right. And how far did you go in school?
college graduate, bachelor's degree.
Where'd you go?
Winston-Salem State University.
Okay.
I also studied business after that at Wake Forest.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses in indictment ending in 194, theft by receiving, 2 counts, and possession of a vehicle with the altered VIN, and the indictment ending in 258? Judge, I'm going to be amending what is currently listed into OCGA 40-3-91. And it's titled Certain Acts Declared Misdemeanors, but it deals with altering VIN numbers and things of that nature, and theft by receiving. In indictment ending 379, there are 3 counts of theft by receiving and possession of a vehicle with the altered VIN. Do you understand that?
Yes, ma'am.
Okay. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Kurt, about all the facts and circumstances known to you regarding these indictments and any potential defenses?
Yes, I have.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Attorney Kurt, do you waive formal reading of this indictment or these indictments and any or all defects therein for the purposes of this plea?
I do.
Mr. Martin, do you remember being arrested on these charges?
Yes, ma'am.
Your Honor, the state's unaware of any outstanding warrants related to this matter. Attorney Kurt, are you aware of any outstanding warrants related to this case or cases?
This case has been an onion.
Yes, it has been. Mr. Martin, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
Okay. For the theft by receiving on all counts, because they are valued at over $25,000, it's a minimum of 2 years and a maximum of 20 years. For possession of a vehicle with the altered VIN for all charges is a minimum of 1 year and a maximum of 5 years. And for the certain acts declared misdemeanors, and that's a minimum of 12 months. And then for the theft by receiving a blank certificate of title, it's a maximum of 12 months.
So in 258, both are misdemeanors.
Correct, Judge. Do you understand that, Mr. Martin?
Yes, ma'am.
Okay. Do you understand that today you are entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes, ma'am.
Do you understand that the court's not required to accept the state's recommended sentence?
Yes.
I'm just going to ask you to speak up a little bit.
Oh, sorry about that.
Okay.
Yes.
Do you understand that the court has a right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? That's true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'd be guilty of a felony which can carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
You understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial.
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
You understand that by pleading guilty, you're giving up the following rights. I'm going to go over 9 and then ask you, do you understand? Okay.
Yes, ma'am.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charges to file a habeas corpus petition challenging the voluntariness of this guilty plea? How do you plead to the charges in indictment ending in 194, theft by receiving 2 counts, and possession of a vehicle with the altered VIN, 2 counts?
Guilty.
How do you plead an indictment ending in 258, certain acts declared misdemeanors and theft by receiving?
Guilty.
How do you plead in the indictment ending in 379, theft by receiving 3 counts and possession of a vehicle with altered VIN 2 counts?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes the evidence would show at trial that this was an investigation in regards to vehicles being stolen. There were multiple reports that APD did receive in regards to several different vehicles being stolen. Ultimately, officers were able to track down these vehicles to 898 Oak Street, Atlanta, Georgia, in Fulton County. And there they were able to recover several vehicles. One of those vehicles being a Mercedes, a silver S560 valued at over $25,000. It was parked in an assigned parking space that belonged to the defendant, Mr. Azell Martin. Officers were also able to obtain search warrants for Mr. Martin's apartment, and there they did locate blank certificates, a title, and things of that nature. Also some key fobs that were located in the apartment complex. Officers recovered a 2023 Chevrolet Corvette at this location, that being the property of Dalvin Matthews. That vehicle had an altered VIN. The Mercedes belonged to Mr. Brenton Cornell. With regard to the indictment ended in 379, there were 3 other vehicles that were also located: a 2022 GMC Sierra that was owned by a Marconi Mora. There is a 2019 Land Rover Range Rover, the property of Douglas Selby, and a 2023 BMW belonging to a Nicholas Hobbs. Officers were able to locate multiple key fobs, so it didn't seem like the vehicles had any damage done to the ignition. However, there were altered VINs on these vehicles. There were fake or blank titles that the officers did recover from the apartment complex. The state is making a recommendation of a probated sentence. We are asking for 7 years total for the defendant to be on probation. We are asking to reserve restitution, but it's my understanding that all the vehicles were recovered and returned. That the defendant complete an anti-theft course. He has already admitted that he is a college graduate, so no GED provision. That he complete 60 hours community service. He have no contacts with the victims, which I don't believe he has any relationship with the victims. Also, there were, I believe, a firearm that was recovered from his apartment and about $4,000 cash. We're asking him to forfeit that cash.
Okay.
1,000 you're saying?
Anything else?
No, Your Honor, that is it.
Do they have?
The 2 of the indictments involved the same date of December 9th, but
Correct.
the lowest number indictment says September 8th, which is, I mean, it's 3 months apart. Does your review of the police records, whatever you've got, show they hit this Oak Street address in September, and then that wasn't a deterrent, and they had to come back 3 months later and got the Sierra and the Range Rover and the BMW?
I was looking at it, Judge, the way I read the report, I'm not sure who drafted the indictment, but the way I read the report is that they were observing the property for a period of time, and then on that December date, they recovered the vehicles.
Including the Mercedes and the Corvette.
That's what I gather.
Okay.
But they did go to that location multiple times. They do reference a September 8th date, but based on the remainder of the report, it appears they got all the vehicles at the same time. And I don't know why.
Okay.
There was one search, Judge, and there was one arrest.
The search was September 8th?
No.
Search was December 9th.
Yeah.
So the search and the arrest are all December 9th. The mystery is what's September 8th? It's in the indictment, and it sounds like it's in a police report as well, but there was no arrest made then, no search then, and so I don't know if they seized the Mercedes and the Corvette. I mean, those are the two nicest cars in the mix.
Is September when they took those?
Yeah.
They took those, but they didn't do an arrest and they came back.
Said knock it off, or we'll be back, or what did they say in September?
Nothing.
Well, just these armed people showed up and took the cars and you had no words with them?
I wasn't even home. I went, when I got to town, went home, the cars were gone.
Oh, well, that would be why they couldn't arrest
Sorry
you.
what happened. He acted like he didn't know. I guess he was working with them, or I don't know.
Who knows? Okay, interesting. All right. Ms. Jackson, I think you already shared with us criminal history for Mr. Martin. Can you remind me how many cycles? This is the gentleman who does have the, what looks like a felony from 2009 in North Carolina when he may have been at Winston-Salem State.
There are 6 cycles, Your Honor.
Thank you. Okay.
I did pull that record back up. If you would like for me to tell you exactly where it was from.
The North Carolina conviction?
Yes, sir.
Okay.
It says Forsyth County District Court, Winston-Salem, North Carolina, for possession of marijuana with the intent to distribute. That date was November the 12th, 2009. And it says confinement 3 months to 4 months, probation 18 months.
Okay. So you guys may want to get your mitts on that document because
Yeah.
maybe that's a misdemeanor given that it's denominated in months, but.
I'll work on it, Judge.
Okay. All right. Thank you so much, Ms. Jackson. That is our last matter for today. So I appreciate you jumping on. And I will see you, I don't know when next, but I look forward to it.
Okay, have a great one. Thank you.
All right. Bye-bye. Ms. Kurt,
Yes.
you already got to tell me a lot about Mr. Martin when we weren't on the record. What do you want to get on the record about
Judge
Mr.
is
Martin
about
in
to
this
turn
case?
40 years old. The one prior significant offense was an offense that took place when he was in his senior year of college at Winston-Salem University, Judge. As I said, he was uncertain of the disposition, but did not feel like it was a conviction, Judge. But sometimes clients can be confused, but I'll absolutely dig in to firm that up any way I can, Judge. Currently, Judge, he works in a number of jobs. He works in a Medicare transport company, Judge. He had a clothing boutique down in Miami that was doing quite well. He helps take care of his elderly parents. He's got other entrepreneur things that he's working on. At the time of this offense, he had gotten a good amount of cash because he was representing a cousin who had a hit song.
Yeah, he had a hit song, went gold, and he had a distribution deal, and they gave us $250,000, and I just took my part of the money, and I thought I was going to start a rental car business in Atlanta because that was the thing, but it didn't work.
I'm not sure if you're familiar with this, Judge. I actually have a number of clients who are doing this these days. You know, you get a handful of nice cars and then you rent them out on Turo or Instagram and Facebook. He's not my only client who's doing this kind of thing, who's found himself in this position. I mean, most of my life I've had more credit than cash, so I go to a car dealership, but he had cash, so he was thinking he was making good cash transactions, you know, getting a good deal because he's paying in full in cash for these vehicles that he in turn was then renting out to people that would find him through various apps, Judge. And this is a business model I'm seeing a lot these days. I'll tell you, in 30 years, I didn't have until the last 2, 3, maybe 5 years. I'd never had a theft by receiving stolen auto case. Those were not the kind of cases that came my way.
Right.
I now have a ton of them. I'm actually working with a DOR agent on another big significant one. My client had 7 vehicles, but we're talking several hundred vehicles that he's recovered across the state. The people who are doing this are really good, Judge. They're good at covering the VINs. My client ran the VINs when he purchased the vehicles, as he told the police officers. And he's like, the VINs come up clean. You know, it's way more sophisticated and it's sweeping in way more people than you would think. As we're in the market for a car for my now 17-year-old, the DOR agent is like, yeah, CarMax, AutoNation are getting burnt by these guys. They're so good. My client did not, you know, there was 3 titles recovered in his apartment, Judge. And there was a note on a pad of paper, get titles, because they came and he's like, these aren't the right titles. I need this guy to give me the right titles so I can get these registered. He was trying to have a legitimate business. Maybe he was naive on the deals he was giving, but I don't think he was trying to run this out in the open in a place full of cameras. As to what was found in the apartment, Judge, he was one of 4 residents. As to everything seen in the parking garage, Judge, he was one of many residents using that parking garage. But he does admit those were the vehicles he was using that he had purchased to run this rental business. And again, you know, that's probably not how you get a car. It's not how I get a car. But I honestly, it's weird how much of this I'm doing these days.
Okay. Mr. Martin, what were the blank titles for?
That's how they came. He sent them to me blank and I didn't know what to do with them. I don't print them. I don't.
Who's he?
The guy that I bought the car from, the Telegram guy. He was like, oh yeah, I'll send you your paperwork. Don't worry about it. Everything's coming in the mail. And that's what I got in the mail. It was literally sitting in a mail envelope in my house and I didn't know what to do with it.
The person from Telegram is the same person for all 5 of the cars here?
No, I only bought 2 cars from him. And then when I didn't get my titles, that's when I stopped.
Buying from him?
Yeah.
Okay. And which ones of the 5 were from him?
That was the first 2. The Corvette and the Mercedes.
Okay.
That's why I had a dealer tag on the Mercedes because I couldn't register any of the cars.
Okay. And what he sent you were blank
It was
titles?
one blank and one was to a car that wasn't even mine.
Wasn't one of the ones you got?
Just
Okay.
sent me something, yeah.
Okay. And then what, on the 9th, when you did get arrested and there was this search warrant, there's reference to a forged title to the Charger, and there's no Charger that's ever
Yeah,
seen.
that's what I was talking about. That's what he sent me and I didn't
Okay.
even have that.
Got it. So that's your one of like, I don't have a Charger. Why are you sending me that?
What is this?
Okay.
And that's why, yeah, it's just confusing.
And this is the same Telegram guy or it's a different guy?
Same guy.
The Sierra, the Range Rover, and the BMW, who did you get those from?
Separate guy.
Separate guy. Now, those were hot also, but it wasn't
Check
the.
the VINs, they were clean.
I'm not doubting that part, but it just, you managed from 2 different guys to get.
Yeah, stolen
Okay.
cars.
And just so I get a sense of
I guess this is
whether your spider senses should have been tingling, what did you pay for the Corvette? It's a 23 Corvette in 23.
paid 20 grand.
Okay. And what part of you did some business at Wake Forest, you got your college degree. What part of your business economic side thought 20 grand for a effectively brand new Corvette is a legit deal?
It was, I'm not buying the car cash. He said he had a car note on the Corvette and I gave him 20 grand to kind of take that over. And he said, oh, well, don't worry about it. I'll help you get the paperwork for the car.
Got
I
it.
never got anything.
And so if Telegram man had followed through, you would have put 20 grand down, but you would have inherited the car note. But that never came to pass.
Never.
Okay. What's Medicare transport?
My sister has a Medicare transport business where she takes people from their home to the healthcare centers. She take them from the healthcare centers to get their medication and then take them there back home. And I just help her organize her schedules for the drivers.
So
do any driving, and everything I do is just office work.
Got it. You don't do any driving. And it's not that your sister is just sort of a fancy medical Uber, but she's got a.
She has a real corporation, yeah.
Okay. All right. And the clothing line in Florida, Ms. Kurt said it was a successful clothing line, but it was
I had an actual store. It's called Swish Clothing.
What happened?
Business partners, and I kind of moved from Florida back to Georgia, and I just kind of let them keep it. They bought me out, and I just moved on. Yeah.
All right. So home is here now?
Yeah.
Do you have kids?
No, sir.
Anything you want to add about this situation? What ought to happen?
I'm sorry for the people that, went through the issues with getting their car stolen and the people that were doing that. I'm very sorry to them, but I'm glad they did. Everybody got their stuff back. You know what I mean? And, just sorry for that situation that I put myself in,
Okay.
Can't keep going for the good deals these days.
No, a $20,000 Corvette, you need to know, it's too good to be true. Not worth the hidden strings that are attached. All right, Mr. Martin, I find there's a factual basis for your pleas in these 3 cases. and also that your pleas are knowing and voluntary, meaning you've understood what we talked about and no one has forced you to enter these pleas. Ms. Kurt, can someone in my office sign your name to the 3 indictments?
Yes.
Ms. Davis?
Yes, Your Honor.
And Mr. Martin, is it okay if we electronically sign your name indicating your pleas?
Sir, Judge.
All right. So, Mr. Martin, I am consolidating these 3 cases for the purpose of sentencing, which is legal speak for, even though it's 3 cases, it's being treated as one sentence. There'll be separate sentences and it's 3 different dispositions. But this concept of conditional discharge can enrobe all 3 if I consolidate them for purposes of sentencing. 2 of them, it makes a ton of sense to, because frankly, that should have just been 1 indictment.
Yeah.
The forged title to the Charger and the 3 stolen car, that was a byproduct. It was a product of the police getting you and searching your place on the 9th. I'm comfortable reaching out and grabbing the September 8th one as well, because you weren't arrested at that time. And it was clearly a tentacle of the police investigation into what they thought was a stolen car ring. It may not have been a ring so much as a little lump of stolen cars, but I think it's reasonable. They're related, connected, to apply the conditional discharge to all 3 and consolidate them for purposes of sentencing. Restitution is being deferred. I don't get the sense there's going to be any restitution based on the nature of these transactions. You bought them clean, you wanted them clean, and well, clean's the wrong word. You didn't buy them clean, but they were nice cars. You wanted them to be nice. You didn't want a side window punched out or a car damaged, because you make more money the nicer they are. So I suspect there's not restitution out there, but if Ms. Davis learns that, wait a minute, the guy who owned the Corvette, when it came back, he had a blue Corvette and it came back, it was red. Maybe there's a discussion we end up having about money that arguably you owe. But if you got it when it was red and when he had it was blue, you're not the one who turned it red. So Ms. Kurt may have some pushback depending on what the claims are. Given the age of this case, I suspect the claims will be 0. On through all these, 25 SC 002194. This is our Mercedes and our Corvette. I am sentencing you on counts 1 and 2 to 7 years probation. And counts 3 and 4 will be 5 years probation. They all run concurrently with each other, so it's a total sentence of 7 years probation. Special condition of probation: 1, complete an anti-theft course; 2, complete 120 hours of community service. You've got the first 18 months of your probation to complete those hours. No contact with the true owners of those cars. That should be pretty easy because you had no idea who they were. It might not even be in Georgia. And I guess the gun and cash, they were seized in December. The only things taken in September were the 2 cars?
Yes.
Okay, so then it's the anti-theft course and the community service and no contact. In 25 SC 002258, those are both misdemeanors now, and your sentence in both those cases will be 12 months, and both those counts will be 12 months. Those will be to run concurrent with, oh, you know what? Yeah, they'll be 12 months each. They'll run concurrently and they're suspended. I don't want you to be on both felony and misdemeanor probation. In Fulton, you'd have 2 different probation officers. That would be confusing. So I'm just suspending that. The special condition of your suspended sentence is obey the laws of Georgia, the other 49 states, and the US. That just means if in the next 12 months you get arrested for something else, in theory, the state could come before me saying, wait, he still have 4 months suspended sentence left and he broke the law, revoke those. And I could. I don't know if I would. It depends what you did. Finally, 25 SC 002379. You see that indictment. Counts 1, 2, and 3 are all stolen cars. So those are 7 years probated. 4 and 5 are the altered VINs. Those are 5 years probated. They all run concurrently with each other. And these 3 sentences across the 3 cases run concurrently with each other. But in this last case, ending in 379, anti-theft course, 120 hours community service, no contact with the true owners of the vehicles, and you forfeit all the things that were seized at the time the police searched your place. Your lawyer has her hand up.
There were other things seized. We've agreed to the gun and the $4,000.
Oh, what else was seized?
My jewelry,
Phones, computer,
computers,
jewelry.
everything, my clothes, my girlfriend's jewelry, her bags.
Wow. And those have been sitting in police property for 2.5 years?
Yes.
Okay. Correction.
Hopefully, if they're still there.
Right. Correction. The gun and the cash are forfeited.
The gun and $4,000.
Was there more than $4,000 seized?
No, Judge. I haven't been to property, but
Yes.
they found $4,000 out. That's what they've asked for.
Okay.
That feels fair.
All right.
The picture I saw.
All right. Any gun, it may be more than one, all guns that were seized.
All guns.
All guns and 4,000 of the cash, which may also be all cash, but 4,000 in cash and every firearm seized from your lair on the 9th of December is forfeited. So if you're trying to get property back, Ms. Kirk will work with me. She may get me a proposed order saying, police, you got to give Mr. Martin some stuff back. It will say no guns. And if there's money, police, you can hold back 4,000 of it. But if there's $4,005, you get a Lincoln. All right. And all that jewelry and all that kind of stuff. I'm sure the clothes are out of style, but they're yours and you can have them.
For sure.
If they still have them. They probably smell great now. That's all I have. You need to report to probation soon, and Ms. Simpson's going to give you those reporting instructions in a minute. Where do you live?
In the West End.
Okay. Ms. Davis, anything else on behalf of the state?
No, Your Honor.
Ms. Kurt, any other negotiating positions on behalf of Mr. Martin?
Did you accept it as a conditional discharge?
I did.
You didn't?
I did.
Did,
EID. Yes.
I'm old.
Remember, I draped it over it. I enrobed
I
it.
heard that, and then you said you were going to take it under advisement. I'm just trying to figure out.
No,
if
the
I'm coming
advisement
back.
part was.
Okay, cool. Thank you, is what I meant.
Yep, that's what I thought. All right. Ms. Simpson, share with Mr. Martin his reporting obligations.
Mr. Murray, what is your
30310.
Okay, so your reporting date will be October the 22nd. And you're going to report to the 276 Memorial Drive, and that is here in Atlanta. And you need to report at 8 a.m.
And you said which day? October?
October 22nd.
Okay.
That's next Wednesday.
Any specific time?
8 a.m.?
8 a.m.
8 a.m. Okay.
Is this right across from pretrial?
Yes.
Okay.
Yep, it's like 2 blocks from here. But don't miss that. That's your first date. You don't want to break probation's heart because then they'll come to me.
Oh, I'm on it.
Mr. Martin, my final observation is that if you and I are together again in this setting, it's going to be because you are a creative entrepreneur, not because you're out there menacing society. Just be thoughtful as you are figuring out what your next chapter is. And if you've got any concerns about, oh, that might be fraudulent or this or that, it's not worth the money you're going to make. Because if we're together again and it's another one of the, well, I didn't know the cars were stolen, that's going to ring hollow. Or I didn't know the real estate wasn't mine or whatever it was. And that'll have consequences on the revocation side. You clearly have a good sense of business, and just if you're not sure which of the 2 options to take the boring one, because that's much less likely to have you calling Ms. Kurt from Rice Street saying, oops,
Yes,
I did it again.
I'm just doing the stock market now. That's it.
Okay.
Wait, one last thing. You said there was an outstanding warrant. Does this resolve it?
No, did I say that?
No, she asked if there were any outstanding warrants,
I
and
thought you were saying because
you
it's
very
before-
forcefully said no.
I was like, oh no, I was thinking, oh Lord, no, we have to deal with that now.
Nope.
No, because like I said, it just, he called me about a theft by receiving,
I don't have any more trouble.
about a gun case. The next thing I know, I was doing an entry on a theft by receiving stolen auto case, and then the next thing I knew, there were 2 more. And so I just figured this was another shoe dropping. Okay, cool.
No, in fact, in our system, the last time was when you were booked in on, they say the 10th, but as a result of this, you stayed in for 24 days before you bonded out. That's it. There's nothing in here. There's no one of those magic orange W's. You don't want that. It means active warrant. So nothing here. And I don't know what North Carolina's doing to you. That's you, but not us.
We'll look into it, Judge.
Okay.
Thank you.
Thanks,
Thank you,
everyone.
Judge. Appreciate your patience with me.
Thank you.
Always a pleasure.
We'll have a better time next time. Yes, take care. Is there anything in my purse?
That's entirely possible.
Right, isn't it?
Oh, no, you put it over here by me when I was sitting. You put a black bag in her name as soon as it's hers.
Right there.
There it is.
Mr. Rivers, do you want me to email you the names too? I just emailed them to Ms. Nelson.